Ah, yes.
Well, sorry to see that. Well, kindly grant me.
I mean,
Yeah.
what has happened? I don't know. Into one my left leg. That's why I'm just limping.
Limping.
Yes.
Well, kindly grant me leave to move an unlisted read petition. We filed yesterday, but due to paucity of time, it was not. It is a tender matter, my lord. Financial bid will be open today. Well, very interesting in this case. The personal assistant of the technical evaluation board has evaluated the technical bid of the firms. It's a very serious thing, my lord. Kindly will.
May I please, Lordship, I may be kindly allowed to move unlisted one transfer matter.
Not today. I'm not feeling well. Not today. Related tomorrow. Tomorrow it will.
Okay, all right.
Same here, unlisted matter. It's
Let it be tomorrow or day after tomorrow. Either Wednesday or Thursday.
tomorrow in that case. No?
Tomorrow, both matters.
Because Lordship,
tomorrow. Okay.
Because Lordship, this item number 10 and this is similar matter. If it can be
Tomorrow
taken.
we'll see to it.
I beg to mention item number 12, my lord.
11.
12, my lord. 1, 2, my lord.
12.
My lord.
Yes, what is the issue?
This matter, my lord, be taken kindly taken up after 2 weeks, my lord.
After 2 weeks.
2 weeks. I have
Have you
informed
taken
other side.
consent of the other side?
My lord.
With the consent of the other side. Mr. Alpha. After 2 weeks.
2 weeks, my lord. Pardon, my lord. Item number 14, my lord. Here I am for respondent, my lord.
Item number 14.
I am yet to receive instruction in this case, my lord. So I am praying some more time, my lord.
Have you filed your affidavit? No.
No, not yet, my lord. I am
Not
not
yet.
my lord.
You're
So,
for the other side?
I'm for the petitioner, my lord. Here, my lord, on the last occasion also, I had expressed only some urgency because the petitioner is going to retire next year. That is the urgency because my service conditions have been modified, my lord, changed without giving an opportunity. Now I have been put in such a position where I am getting less payment from my juniors, my lord. No other friend. I've been just.
So how many weeks you need? 1 week or 2 weeks?
I am praying my 3 weeks, my lord.
3 weeks may be difficult for him.
My lord,
because
then let
he
it
is
be
going
listed.
to retire as per him.
Yes, my lord. Let it be listed in the first week of December, my lord. My lord will make it clear, my lord, that there is some urgency, my lord. Otherwise, it was reflected in last order also.
But first week of December, in November itself, it can be fixed.
Well,
Otherwise-
since my brother is praying for 3 months or 3 weeks, my lord, so I'm say let him file the affidavit, my lord. Let him give the time, my lord. But let it be listed in first week of September or December, my lord, for admission.
With the consent of the other side, Mr. Alfami, the learned counsel for the respondent, paid for an internment, enabling him to file his affidavit in opposition. However, Mr. Suki, the learned counsel for the petitioner, raised objection and submitted that matter is urgent, and he submitted that, and accordingly he submitted that the next date of listing matter may be heard. And let the matter accordingly be listed. Yes, get appointable December first week, any date. 3rd of December will be
My lord.
3/12/2023.
Lord.
High elevation.
Ma'am, my lordship, I beg to mention item number 20, my lordship.
20. Yes.
In this, our affidavit is ready, my lordship. We need 1 more week to file affidavit.
Fine, my lord.
Because
Because the
affidavit, you need 1 more week. Or
1 week.
1 week.
Because the gentleman is occupying the public office after interpolating the date of birth after 15 years of service. So, which date I can it be on 19th of November
will be okay.
in the admission column?
Yes, in admission column. Otherwise, it is in order column. Why it is in order column?
Because he has not filed the affidavit.
Our affidavit is ready, my lordship, will be fine.
Okay, so it can be posted in admission column?
Admission column.
Consent of the, no, with the consent of the other side, standing counsel will be on. Here. So and so, is paid for an adjournment, and I bring her to file this affidavit in opposition. However, she submitted that affidavit is already ready, and it is going to be filed within next week. Let the matter accordingly be listed on 19th November. Okay, we're listing it on 19th.
And one more, my lordship, item number 22. This matter is listed after 2 weeks. Supplementary hearing. Consent has-
22.
Yes, ma'am, consent has been taken.
It's a matter of 2018 in
Yes, ma'am, after 2 weeks.
here you are appealing for
Respondent,
respondent, government respondent. Same prayer for it. Now see, this is of 2018, any Tuesday, Thursday, but aside you. 18 is Monday. 19 is Tuesday. You're fixing it on 1911, or
19,
you want 2 weeks?
after 2 weeks.
So 2 weeks की मात्रा दे दो. Then can it be on 21st of November? Thursday, no then. Huh? 21st of November. Right, Thursday. So we are fixing it on Thursday, hearing date, 21st of November.
I beg to mention item number 4 and 5. The motion is this here. We are supposed to file additional affidavit in this case, Your Worship, but we have received a record this morning only, Your Worship. So item may be listed day after tomorrow. We will file
Yeah,
tomorrow,
tomorrow may not be possible. Let it be on 18th or 19th.
18th.
Because this week are very big one, 13th time, we're going to fix it with the matter.
Then on 15,
Huh?
on 15, yes.
15 is a holiday, I think. Maybe on 14th.
14,
14th is a working day. 14th. 15th is a holiday.
okay.
Oh, that's why. So 14 will do.
Then
Or if you want, then 18 or 19, it can be posted.
on 17, Your Worship.
17 is again is a holiday, Sunday.
17 is,
You're choosing all the days of holidays, huh?
okay, then 18,
18th?
yes. 18.
18. You're for the petitioner. You're
Yes, I am
going
for
to
the
file
petitioner.
additional.
Yes, additional.
You're for the other side? So still. 18th, 11, and I'm bringing the petitioner side to file the additional. You're going to file additional.
Yes, yes.
No. 18th.
Deeply obliged.
Okay, but
May it be please, your lordship?
is a poorer of a yes, sir. Please tell me. Yes.
Your lordship, I beg to mention item number 11. I'm on behalf of Mr. T. Tarum. Your lordship, he's out of station because of that, your lordship, and
You are for the petitioner?
yes, for the petitioner, your lordship.
Item number 11.
11, yes, your lordship.
You're appearing on behalf of?
T. Tarum, your lordship.
Come to an item.
T. Tarum.
Name is not reflected in the,
Your lordship, his junior's name is there, your lordship, NH, teenage, your lordship. And your lordship, this matter may be listed on this 8th of November, your lordship.
8 of November is Friday. Friday. আগৰ কিবা আছে নেকি দিছে? পাৰিম? 8 of November পাৰা যাব। এইটো নম্বৰ এনে বেলেগ কোন আছে নেকি? বোৰ্ড আছে। টিউজডে অলপ কমাই ৰাখিব, বেডনেছটো নাৰাখিব। Seeing 8 may not be possible, make it on 11, Monday.
Yes, your lordship. Deeply obliged, your lordship.
Lordship, I beg to mention item number 24 and 25. And I've taken the consent from the other side, and I'm appealing for the petitioner side. Senior counsel, due to some health issue, cannot
Who is the
appear.
senior counsel?
AK Prakash.
AK Prakash.
Yes. Kindly, Lordship, this matter may be fixed for 6th December.
With the consent of the other side, the learned counsel for the petitioner paid for an adjournment stating that the against counsel, Mr. AK Prakash is not given well. Stop prayer allowed. Let the matter be listed on 6th December. You
Sixth.
want?
Yes.
6th.
December.
Both the matters?
24.
Both the matters?
Yes,
24 and
24 and
25.
25.
Oh.
May I please, Lords? My lord, although, my lord, in this matter, my lord, no notice has been issued, but respondents have filed their affidavit in opposition, my lord, on instruction. And I have also filed my affidavit in reply. Well, this
Both the
matter,
cases at the stage of motion stage.
yes. Well, on instruction, they have filed their affidavit in opposition, and I have also filed affidavit in reply, my lord. Well, this case is otherwise ready, my lord. If your lordship permits, my lord, it can be disposed of today, my lord.
So state is representing all the
Yes, yes.
1, 2, 3, 4.
No.
And you have filed your
1 to 3 laws.
1, 2, 3.
3. All laws.
1, 2, 3.
So matter can be hard laws.
Pardon?
Matter can be disposed of too.
Hard. Okay. Okay, yes.
Amen. My lord, the petitioner has participated in a notice inviting tender, my lord. Issued on 27 February 2024, my lord. Annexed 1 phase 16, my lord. Thereafter, my lord, this phase 16 is the, my lord, NIT, notice inviting tender. My lord, this is regarding construction of OCR complex at Longding district, my lord. According, my lord, since the petitioner is, my lord, eligible to participate in this tender, he participated in this tender. And one more firm also, there is 2 firms have participated in this tender. And after evaluation of their bids, my lord, the petitioner was recommended for the award of the contract, my lord.
Recommend.
Petitioner was recommended for award of contract.
Acha.
That bid evaluation committee has recommended the petitioner to award the contract. My lord, accordingly, my lord, it comes to page 22. Page 22, my lord. Annex 4, page 22. My lord, this is the letter of acceptance, my lord, issued by the respondent to the petitioner, my lord. My lord, in this letter of acceptance, my lord, last second paragraph, my lord, kindly come to last second paragraph. Further, you are requested to attend this office within 7 days from, I'm sorry, my lord, second, third paragraph, my lord. Therefore, you are here requested to furnish the performance guarantee / security in the prescribed format. This detailed in paragraph 3.1 of RTB for an amount equivalent to 5,50,000. My lord, the petitioner was directed to deposit the performance security, my lord. This means performance guarantee, my lord. However, my lord, what's happened in this case, my lord? This letter of acceptance, my lord, was not communicated to the petitioner, my lord. Therefore, my lord, petitioner did not submit this performance guarantee as they asked. Thereafter, my lord, if you also come to page 20, my lord.
20.
20, my lord. The letter written by the executive engineer to the superintendent of superintending engineer, my lord. In this letter, they have, my lord, said, may I read, my lord? With reference to letter number dated above, the letter of accession has been given to NS Enterprises, that is me, my lord, longing to submit the performance guarantee of security by on letter number such and such, dated such and such, on the basis of approval received from your office. Now, after issue of 10 days, I'm sorry, my lord, now after lapse of 10 days, neither the contractor has furnished performance guarantee, nor any correspondence is received from the contractor. Therefore, it is requested to kindly communicate a suitable instruction in this regard as early as possible. However, this letter was received by the petitioner after expiry of this, my lord, 7 days, my lord. In the letter of extension, they have asked me to submit the performance guarantee within 7 days, my lord, that I received on 30th of June, my lord. 30th June, my lord. This was issued on 24 June 2024, and I received this letter on 30th of June, my lord. 30, my lord. Thereafter, I made an inquiry, my lord, and thereafter I come to know that this letter of acceptance has been issued on 12th of June 2024, but that is not communicated to me. As such, my lord, I am not, my lord, able to submit this performance guarantee as, my lord, asked by the respondent. Thereafter, my lord, in page 24, my lord. My lord, in the meantime, my lord, on many occasions, my lord, this petitioner went to the office of this respondent, my lord, executive engineer. But, my lord, since that incumbent executive engineer was already transferred, my lord, therefore, my lord, his performance guarantee was not taken. As, my lord, there is no authority, the staff had told me that they have no authority to receive this performance guarantee after expiry of 7 days, my lord. Thereafter, my lord, the
But
page 20,
you are directed to give the performance guarantee within 10 days.
7 days, my lord.
No, only later by 20.
By 22, page 22 is this letter of acceptance. By this letter, I was directed to submit the performance guarantee within 7 days. But because of this, my lord, miscommunication, I could not able to submit my performance guarantee, my lord. Therefore, my lord, on my lord, page 24, my lord, I have, my lord, submit one, my lord, submit by way of written, my lord, application, my lord, showing my intention to submit the performance guarantee, but they have not received. They have, my lord, denied to receive my performance guarantee because 7 days time is already lapsed. Hence, my lord, I have filed this writ petition, my lord, seeking direction from this honorable court to the respondent to accept my performance guarantee, my lord. My lord, kindly, my lord, appreciate, my lord. This is, my lord, this is regarding, my lord, construction of, my lord, OCR complex, my lord. And, my lord, the NIT has been called for. I am duly, my lord, recommended by the board for my lord, award of the contract. But because of this communication, I couldn't able to submit my performance guarantee on time, my lord, because of this miscommunication. Otherwise, my lord, they are, my lord, now going to issue a fresh tender, my lord. My lord, if fresh tender is issued, my lord, lot of, my lord, this time and, my lord, financial involvement is there, my lord, which will not beneficial for both of us, my lord. In my humble submission, my lord, let the respondent may be directed to, my lord, accept my performance guarantee. My lord, if required, my lord, let some penalty may be imposed of the petitioner. That can be done, my lord. That is my humble submission, madam. And I will reply subject to my, what my senior.
Lordship, see, he's a conductor by Lordship, occupation Lordship. He's supposed to know Lordship the movement, the development taken place in the department Lordship. After once you have been selected Lordship, so you are supposed to know Lordship. And apart from that Lordship, if Lordship come to page 33 Lordship of my affidavit. When this writ petition was filed, Lordship, this Everman Lordship, that is not their Lordship, this copy Lordship, letter to the Lordship petitioner, directing him to submit the Lordship performance security. Page 33 is the Lordship on one Puchet Wangsu, on the top Lordship, page 33, Wangsu. He received Lordship this particular letter for MS and so and so and so Lordship.
On when?
It was received on 14/6 Lordship. On left hand side, Lordship will find the date Lordship. 14/6. Letter is of 12 Lordship. And it was served on 14. And it was served in his own residence Lordship. This Pujet Wangsu, he was in his residence Lordship. And it was served to him. And this aspect has not been Lordship brought on request by the petitioner in the writ petition Lordship. Now they are Lordship admitting that it was received, but only if Lordship sees the rejoinder Lordship. They deny Lordship he is relative to the petitioner, but it's admitted the Lordship he is a blazer, resident of that blaze Lordship, and it was received Lordship. Now, whether he is a relative or not Lordship, this is not disputed facts Lordship. Our categorical stand is that Lordship. This man was Pujet Wangsu is his relative and he was in his residence. Otherwise, there's no point Lordship we are serving this letter to some other person who is not related to the petitioner. And I'll go to other's house and I'll serve it. There's no logic behind that Lordship. So it was served in his own residence Lordship. And Lordship, what terms and conditions says Lordship? If you fail to deposit the Lordship, performance security Lordship, then we are bound to Lordship reject cancel your tender Lordship. So what we have done here in this case Lordship. Now after Lordship, it has been cancelled Lordship.
It already been cancelled.
It has been already cancelled. And that cancellation has not been put to challenge in this writ petition Lordship. And petitioner decided not to challenge that Lordship. Because he has not challenged. And day one Lordship, he was apprised Lordship, this has been already cancelled Lordship. Initially, it was moved on Lordship 21 August, this writ petition Lordship. The present writ petition was moved on 21 August Lordship, 21st August Lordship.
This is petition.
Lordship.
First time I see it.
On day one Lordship, that is 21st August 2024 Lordship. I was directed to bring the instruction Lordship.
Oh, achha. Yes, it's 21st of.
Yes, Lord. I was directed to Lordship bring the instruction Lordship. Why Lordship this has been cancelled Lordship. Then on next date is the 28/8 Lordship. Immediately after 7 days Lordship, it was listed again Lordship. Then Lordship, I brought the instruction Lordship. I was supposed to file affidavit in opposition Lordship. Accordingly, it has been filed Lordship. Then it was listed on 3rd October Lordship, and now then again on 22nd, and today Lordship again it is listed Lordship. Now, why I'm pointing out is Lordship. If Lordship say, kindly come to next page, that's page 34 Lordship. We have served a copy. Then when there's no response and no performance security was deposited Lordship, then what steps we have taken Lordship? 27 June. With reference to the letter number 7, so it is to say that the tender for the works mentioned below, letter of acceptance already given to MSNH Enterprises in the condition that MSNH Enterprise will furnish the performance guarantee of security in the prescribed format, detailed in para 34 point of ITB. This instruction to bidder lordship for an amount equivalent to rupees so and so. 5,50,000 only within 7 days of the issue of acceptance letter dated 12/6/2024. Now it has become more than 15 days. This office not yet received any response from his side. Moreover, for the said work, tender has been called 2 times, but could not success as the contractor MSNH Enterprise could not submit the necessary document for technical bid and also failed to submit the performance guarantee and also non-response from which it seems that the contractor is not interested lawsuit. This is the intimation by the executive engineer is the lawsuit tender plotting authority and here higher authority. This intimation has been lawsuit brought to the knowledge of higher authority lawsuit. Here just post for a moment lawsuit. This is the third tender. Earlier also this same tender was floated lawsuit. The petitioner participated, he could not succeed in the technical bids. Since none were lawsuit eligible, again it was cancelled. Then again retender. Now in this retender lawsuit, he was selected, but again he is lawsuit not submitting the performance guarantee lawsuit. Then in response to that, if lawsuit come to page 35 lawsuit. This is past July lawsuit. This is by executive engineer longing to, SC for SC response is with reference to letter number so and so cited subject cited above includes find here with the approval for retender for the work constructions of so and so at so and so with duly proper cancellation order. In this regard, for the aforementioned work, it is suggested for recall of tender observing all correct performance. Now, approval has been given lawsuit for retender by after issuing the proper cancellation order lawsuit.
Yes.
Now, at page 36 lawsuit, come to next page lawsuit. This is the cancellation order lawsuit. Here lawsuit citing this grounds lawsuit. The tender has been already cancelled. Just like I'll read the second paragraph lawsuit. Hence, in terms of the approval order so and so, the tender awarded to MSNH interview here were cancelled and press tender should be plotted at the earliest. And on the bottom lawsuit, copy has been marked to the present read petitioner lawsuit. Now, when the lawsuit tender has been cancelled lawsuit, this cancellation order has not been challenged lawsuit. Now, this is the lawsuit logical and ultimate conclusion of the department lawsuit, which should have been lawsuit challenge if he is at all aggrieved by lawsuit. But he is not aggrieved by his cancellation order lawsuit. Until unless his cancellation order is revived lawsuit, how he can be allowed to continue the lawsuit, the tender lawsuit. So this is the lawsuit, the facts lawsuit, how lawsuit, the tender of the petitioner has been cancelled lawsuit. Lawsuit, see, the press tender, we are not in position to press tender because earlier there was an interim order. If not plotted lawsuit, not to lawsuit plot lawsuit. So public interest is lawsuit highly prejudiced because of this situation lawsuit. Therefore, lawsuit, this rate petition may be dismissed and we may be allowed to lawsuit proceed with the press tender. In that press tender lawsuit, petitioner is open to participate again lawsuit. There's a negligence on his part, apparently lawsuit. That's my submission lawsuit. And one small there's a dispute lawsuit. We say that lawsuit, your relatives has received lawsuit. He is not my relative lawsuit. This disputed facts cannot be lawsuit decided in a read petition lawsuit.
I will answer that.
That part.
I will answer that. Ma'am. Hello, kindly come to their affidavit in opposition, my lord. Page 28, my lord.
Page?
Page 28, my lord, their affidavit in opposition. My lord.
Yes.
Paragraph 5, my lord. My lord, from down, line 1, 2, 3, 4, 5, 6, from down, my lord, come to, my lord, sixth line, my lord. My lord, this, my lord, kindly from down, my lord. Line 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. And to serve, there is sentence. And to serve the same copy of letter of acceptance, Sri Muhammad Ali, who is working as a casual fan in PW Loaning, went to the resident of proprietor of MS such and such, and accordingly, the same was received on 14/6/2024 by the family member of the proprietor of the NS Enterprises, Longding, namely Sri Puchet Wangsu, as he had taken full responsible and the recipient of the said letter of acceptance had put his signature and name in the office record of PWD family from his own hand. My lord, kindly appreciate, my lord. My lord, this letter of acceptance, my lord, I will say otherwise it is like notice, my lord. Notice to me, my lord. And in my humble understanding, my lord, notice should be served in person. If, my lord, although this writ petition, in writ petition, CPC is not applicable, my lord, but spirit is applicable. Notice should be served to the concerned person in person, my lord. If that is not possible, my lord, to the family member, my lord, major family member, and if that is not also possible, they are not available, my lord, it can be affixed in some conspicuous, my lord, area, my lord, so that I can notice that. My lord, they have served this notice to someone, Puchet Wangsu, my lord, who is neither my family member, nor he is residing with me, so as to call it is an agent, my lord, my agent. You are serving my notice to some stranger, my lord. Now, how can you dispute, my lord? On oath, I'm saying that he is not my relative, not my agent, although he is a co-blazer. That is admitted fact, my lord. But, my lord, law does not permit, my lord. You should serve the notice in person to me. If not possible, to my family member, major family member, that is law, my lord. I have, my lord, I have filed affidavit in reply, my lord. Kindly come to page 38, my lord. Affidavit in reply, my lord. I will read, my lord, my affidavit in reply. Affidavit in reply filed by the petitioner. Yes, ma'am. Page 38, para 3, madam. That with regard to para 5 of the affidavit in opposition, the deponent denies that the Sri Puchet Wangsu is his family member. He is neither his family member nor residing with him in his house, although he is co-blazer of the deponent. It is very unacceptable that the answering respondent has handed over the letter of acceptance to a stranger who is not a family member, agent, etc. of the deponent. It is a duty of the answering respondent, it should be a respondent, to serve a notice to a deponent personally, and in event of his absence, to a major member of a family, or to affix the notice to some conspicuous place where the deponent resides. This is the law, my lord. I not need to place any judgment on this, my lord. My lord knows it. Serving the letters of exception to a stranger who is not a relative or agent of the deponent will not, if so facto, absolve the respondent from their bounden duty to serve effectively, my lord. But issue is where effectively it was served or not. That is the issue, my lord. And thereafter, my lord, I will further go, my lord. Para 4, my lord. That with regard to the para 6 to 8 of the affidavit of opposition, deponent does not admit anything which is contrary and inconsistent with record. The deponent begged to state that, my lord, my learned friend has, my lord, applied this court about certain, my lord, subsequent development, my lord. Whether that subsequent development, my lord, that subsequent letter has been communicated to me also, my lord. That is my answer, my lord. The deponent begs to state that all the subsequent letter as awarded in para 6 of the affidavit in opposition was also not communicated to the deponent. It was came to the knowledge of the deponent only on 28/8/2024 when instruction was placed before this honorable court by the answering respondent is director. This letter was also not communicated to me, my lord. Thereafter, my lord, if I say, my lord, if I submit, my lord, this whole, my lord, act or action of the respondent shows malafide, my lord. My lord, a prudent man, my lord, who has, my lord, own the my lord, the contract, my lord, a prudent man, my lord, who own the contract, will not, my lord, do something which is detrimental for his interest, my lord. It is submission of performance guarantee, my lord. I am recommended to award the contract work. A submission of performance security, 5,50,000. I'm a class 3 contractor. I am not able to submit that, my lord. If this communication has been, my lord, this letter has been communicated to me, my lord. And they say, my lord, this subsequent, my lord, development which has been taken place, my lord, that has not been challenged, my lord. Kindly see, my lord. What is my prayer, my lord? My prayer is, my lord, my prayer is kindly direct the respondent to accept my bid, my lord. Because that letter of acceptance is not communicated to me. That is the issue, my lord. And my lord, once it is, my lord, established, my lord, if I, my lord, I will establish that communication, that letter has not been communicated to me, my lord. My lord, if this honorable court, my lord, finds that, my lord, every subsequent orders will automatically go, my lord. It will be, my lord, relate back to its own, my lord, position, my lord. Because that will not impede there is no impediment of this honorable court to issue a direction to accept my performance guarantee, my lord. My lord, I have, my lord, given everything, my lord. Because, my lord, law is clear, my lord. Your lordships know, my lord. Law of notice. What is law of notice, my lord? And this letter of acceptance is like notice, my lord. You submit the performance guarantee within 7 days. This is notice, my lord. And it has to be served effectively, my lord. That's all, my lord. Therefore, my lord, this matter may be, my lord, allowed, my lord. And, my lord, respondent may be directed to, my lord, accept my performance guarantee, my lord. My lord, 5 minutes before I said, even if, my lord, penalty is imposed, I'm ready to give. But now, my lord, I think, my lord, on merit, I will ask this prayer, my lord. Obliged, deeply obliged.
Just a small thing. Since my pen has raised the lawsuit, prayer lawsuit. If lawsuit see the prayer lawsuit, what is prayer lawsuit? Not to cancel the tender. Tender has been already cancelled lawsuit. The government approval order is not under challenge lawsuit. Cancellation order is not challenge lawsuit. Until unless that approval and cancellation order is revived lawsuit, how the award can be lawsuit given to the petitioner lawsuit?
Not award. Just
It has been already cancelled lawsuit. Rather, the writ petition become in process lawsuit.
no, my lord, kindly come
Technically, the writ petition
let's come to
become
my-
in process
my
lawsuit.
prayer.
Not to cancel because it has been already cancelled.
my lord,
Prior to filing of the writ petition, it was already cancelled lawsuit.
let's come to my prayer then. Let us clear first, my lord. First prayer, my lord. page 12. A writ in nature of management shall not be issued directing the official receiver not to cancel the NIT dated such and such issued by executive engineer loanings by number such and such and such and such. A writ in nature of management, para 2, my lord, shall not be issued directing the official not to issue a press tender, my lord. Okay, my lord, this prayer number 1 maybe goes, man. But prayer number 2, a writ in the nature of management shall not be issued directing the official responder not to issue a press tender for work of construction of OCR complex at IB Lounding under SIB Dibrugarh. Then, my lord, prayer number 3, a writ in nature of management shall not be directing the official responder to accept the performance guarantee furnished by the petitioner in terms of letter of acceptance dated such and such issued by executive engineer such and such. My lord, this although this prayer number 1 maybe goes well, but prayer number 2 and 3 is still remains well. Obliged, deeply obliged.
I'll pass you.
Obliged.
Obliged.
May I please, madam? My lord, this, in this writ petitions, my lord, I'm challenging the action of the respondent, my lord, and more particularly the deputy commissioner, in acting contrary to the act, my lord, which is 2003 Act is there, my lord, for eviction of the unauthorized occupants act. My lord, basically what happened, my lord, in the year 2021, my lord, I was allotted a quarter, my lord. If your lordship will take up item 3, my lord.
Item 3.
3, my lord. Item 2 was filed earlier, my lord. Now item 3 is the fresh, my lord. .483 is the item 2.
Yes.
Yes. If your lordship would come to page 22, my lord. Annexer 1, my lord. I've annexed some photograph. This is the quarter that was allotted to me, my lord. And this is the picture when I took possession, my lord. My lord will see the picture, my lord. It's not fit for human, my lord, habitation. Somehow we managed, my lord, but in this year, my lord, in 2024, my lord, in the June, July, my lord, this building collapsed, my lord. When this building collapsed, I approached the departments, and before that also, my lord, I approached my department for maintenance, my lord, but nothing happened. Now, when this collapsed, my lord, I started construction, man, since I have nowhere else to live, man. So in the month of August 30, my lord, 30 August 2024, my lord, I received a notice, my lord, from the estate officer to stop the construction. So I stopped the construction. I replied, my lord. And on 12th of September 2024, my lord, the estate officer passed an order, my lord, directing for eviction of the construction, dismantling of the construction. So against that order, my lord, I filed an appeal, my lord, before the deputy commissioner, my lord. Section 12 of the Act, my lord, it provides for a statutory appeal before the deputy commissioner, my lord. I preferred an appeal, my lord. Next page, my lord, page 23 is annexer 2, my lord. That is the appeal, my lord. So, my lord, what happened, my lord, when this appeal was filed, my lord, the deputy commissioner refused to take up the matter, my lord. And well, this is the original, my lord. Refused to take up, my lord, that the original was returned to me, my lord. Meaning thereby that there was no appeal petition pending before the deputy commissioner. This was returned to me. And that's why I preferred the writ petition 433, my lord, that item 2, my lord. Since the deputy commissioner statutory act is there, providing for an appeal, I filed an appeal, but the deputy commissioner is not taking up the appeal, my lord. So in item 2, my lord, an order was passed, my lord, directing for maintaining of the status quo, and liberty was given to the deputy commissioner to decide the appeal in the meantime. But of course, it was not brought to the attention of this court that the appeal petition was not there before the deputy commissioner. The original, it was with me, man.
In item 2, Was direction was there. In item 2, direction was there.
Yes, my lord. In item 2, there's a direction. That order otherwise I have annexed in item 3, my lord. That order is on 25/9, my lord.
Hmm. So it was asked to maintain status quo. What do you call that?
Maintenance status quo, my lord, and liberty was given to the deputy commissioner to dispose the appeal if is there. So then, my lord, but however, my lord, that if your lordship,
But while returning you the memo of the appeal,
yes, ma'am.
if it is returned by the deputy commissioner,
Yes.
was there any order passed by him
No, nothing, my
that
lord.
he is not in a position to take up the matter or whatever?
Yes, nothing, my lord. They will just refuse, and it was marked to the estate officer, my lord. I've annexed this, my lord, at page 23, my lord. If your lordship will see page 23, man. It has refused to take up and mark it back to the estate officer, man. Otherwise, I am in appeal against the order of this estate, order passed by the estate officer. And he says, you go back to the estate officer, you will not take up. So that's why I had to come, my lord, approach this court by filing the WPC 433, which is at item 2, man. Now, my lord, pursuant to an order that passed by this honorable court in item number 2, man. At page 28, my lord, the deputy commissioner passed an order, man.
Page 20 of item 20.
No, page 20, this item 3, man.
3.
Page 28, and my lord, type copy is at page 29, man. This is of 1st October, my lord. The date of hearing the matter of appeal petition dated 17/9/2024 under the provisions of section 12 of the so and so filed by so and so against the order of the ADC office of estate officer white number so and so dated so and so has been fixed on 7th October 2024, man, at 15:30 hours in the office chamber of the undersigned, man. So
It was fixed on
7th
7th of October.
7th October.
Thereafter, what had happened?
7th October, my lord, it was fixed, my lord. So the petitioner appeared, my lord, on 7th, man. But there was no records, my lord, because the appeal petition, the original has been returned, my lord. So the deputy commissioner said, you file a written appeal, man, fresh appeal, man. So accordingly, I filed one written appeal, my lord, fresh appeal on page 30, man. This was received on 16th October, man. This was received on 16th October, and then the petitioner was under the belief that hearing would take place pursuant to the filing of this appeal. But surprisingly, my lord, the impugn order has been passed at page 36, man. Back date, man. And this was served only on 22 October, man. After the filing of the fresh appeal, man. It's down below, my lord, would see, my lord, received by Miss so-and-so. She is the elder sister of the
No, the
petitioner.
matter was fixed by the deputy commissioner on 7th of October.
7th October, man.
Prior to that, you have filed, that was the direction that you file a fresh appeal.
Yes, on 7th, my lord, because there's no appeal petition there, my lord. So there was some verbal instruction was there between the petitioner and the deputy commissioner. Nothing, no evidence, nothing, no proceeding took place. And since there was no appeal petition, and the petitioner also informed that I have given the original to my counsel for filing a writ petition, my lord, the item 2, my lord, which I preferred earlier. Okay, the time was given. I was given time to file it by 15, my lord. I filed on 16, my lord. Of course, there was one day. But surprisingly, my lord, this order, my lord, backdated order was given, my lord, 7th October. So my basic, my lord, my lord, contention is, without there being any appeal petition pending before him on 7th October 2020, this order has been passed in a predetermined manner. The way he had already refused, my lord, in item number 2, my lord, he had already refused to take up the matter, and in a mechanical manner, he has again passed this order on 7th October, my lord. Because, my lord, the Act provides for statutory appeal, my lord. It has to be dealt with, my lord. It has to be taken up in accordance with the Act, my lord. It cannot be disposed of like this. Nothing, my lord. The Deputy Commissioner calls me, no appeal petition, nothing, my lord. Gives me time, my lord, and then passes this order, my lord. That is my basic case, my lord. So may I play, my lord? My lord, to call for the records and see whether any appeal petition was there before the Deputy Commissioner on the 7th of October, my lord.
Can you file your fresh appeal memo on
16. That was the time given to me, my lord. 16 I filed, my lord. So may I pray, my lord, at this stage, my lord, let notice of motion be issued, my lord. And my lord, may call for the records to see, my lord, whether there was any appeal petition, my lord. And in the interim also, my lord, I'm praying, my lord, that status quo order, my lord, regarding the possession of the water and the construction, my lord, that may be passed, my lord. Because this cannot be, my lord. I cannot be deprived, my lord, in this manner, my lord. At least he has to hear the appeal, my lord, in some manner, my lord. There has to be an appeal petition. Some evidence has to be adduced.
Item number 2, you have filed the item number 2 after the refusal of.
Yes,
taking.
after the refusal, my lord. After the refusal, my lord. And he has again, my lord, this Deputy Commissioner, my lord, reiterated the same, done the same thing basically, my lord, just to frustrate the writ petition, my lord.
Yes.
Lordship, before I come to the this appeal order, Lordship, by the Deputy Commissioner, Lordship, this 433, item number 2 was filed. Lordship, here in this properly so-called notice was given, Lordship, Lordship, at page 26.
26,
item
number 2.
Lordship, and then Lordship, in the reply also, Lordship will see here by the petitioner, Lordship.
In which item you are dealing with? Item number
2. Because item number 2 is also listed,
433.
Lordship.
433.
433.
Page 26.
Yes,
Page
Lordship.
26.
This is so-called notice to the petitioner, Lordship, by the estate officer. Wherein he have, after dismantling the government structure, is building a RCC residential building there. Lordship. The so-called notice is regarding that, Lordship. At page 12, Lordship, his reply to the so-called notice, Lordship. Herein what he have given is, Lordship, the region. It's Lordship 2 and 3. At page 28. Serial number 2 and 3, Lordship. Lordship. Here, reply, he says that the quarter which was allotted to me was in dilapidated condition. I have made numbers of correspondence with my department, but no initiatives have been taken from the side of department. Thus, the quarter was collapsed. That since I have no own accommodation in Daporeja Township, I had no choice but to construct a temporary kacha house for my family. And following the ongoing trend, Lordship, of occupying government land, I too have erected RCC pillars for constructions of house. He's clearly admitting, Lordship, just because trend is there. Lordship. So, Lordship, this is the Lordship appeal under section 12. This is appeal itself. This is page 28 is Lordship. When notice was issued, Lordship, we have sent this copy to the petition copy to the Deputy Commissioner. So actually the appeal petition was with the Deputy Commissioner. So when the notice was issued, the order was issued that the hearing will be taken up on 7th, Lordship. Since the copy is there, that's why he have taken up. And the petitioner was present in the room, Lordship. Lordship can see here in the page 36. In the item 3, Lordship, 483. Lordship got it? Lordship. Lordship here had a appeal petition today filed under the provision so and so by Sri Tasi Mosung, resident DST Colony Daporeja, against the order of removal eviction of the illegal construction structure on the government land by the Edusicam Estate Officer, Lordship. This, Lordship, after this, Lordship, the appellant Sri Tasi Mosu was present, Lordship. The appellant has stated that he may be allowed to proceed further and complete the construction of the said building on the government land. Lordship, on the government land, how he can, in place of the quarter, he can build a RCC of his own, Lordship. How that can be allowed, Lordship? And this is not legal at all, Lordship. This cannot be, Lordship, not permissible. That's why, Lordship, the Deputy Commissioner, Lordship, the appellate court have authority have passed this order, Lordship. And then in the Lordship,
Can you tell us what about his fresh appeal memo that he is saying that on 14th?
Lordship, he is saying that, but in written there is nothing where he have been asked to file press appeal, Lordship. There is nothing, Lordship, in the order. Lordship can see this. Just a
No,
second.
there's no communication on the dated order of 1st of October. He was simply asked to present.
Yes, Lordship, that only. This is only Lordship, the submission of the petitioner that he was asked to file fresh appeal, Lordship. Only that. Even in the Lordship, Honorable Court's order, Lordship, in page 27. Lordship, at para 8, Lordship. On a direction of the court, the learned counsel for the petitioner has produced 2 photographs of the construction site. The printout of the said 2 photographs are made as a part of record. Taking note of the nature of construction carried out so far, the court is inclined to prohibit the petitioner from proceeding with any further construction, Lordship. From here, Lordship, it can be clearly seen that, Lordship, the petitioner doesn't have any merit in this case, Lordship. So there is no, Lordship. Use issuing, Lordship, notice and all, Lordship. 8 per Honorable Court's direction also, Lordship, 8 per procedure also, the Deputy Commissioner, the appellate court, appellate authority has already passed the order.
Yes.
My lord. My lord, whether notice was served or not by the estate officer, those are not disputed. I'm admitting to it. Those notices were served, everything, man. But whether the order passed by the deputy estate officer is right or wrong, whether I had dismantled, my lord. Because there are lots of things, my lord. Since
You have
I'm,
admitted that you have erected the pillars and all on constructions.
yes, my lord. Of course, my lord. That I have admitted, my lord. I cannot deny that, my lord. I've admitted, my lord will see the condition of the quarter, my lord, that was allotted to me, my lord. But the order of the deputy commissioner, the estate officer, is influenced by his decision that I had dismantled, my lord. These are things that I have filed an appeal, my lord, against which I have preferred an appeal, my lord. So it has to be taken up. It has to be decided, my lord. Because otherwise also, my lord, since this writ petition is not an appeal against the estate officers, I have not stated those facts, man. Because the otherwise the estate officer no witness, nothing. The deputy commissioner also no witness, nothing, man. Not even an appeal petition, my lord. This is a categorical statement that I have made in the writ petition also, my lord.
Calling for the records.
Yes, my lord.
I mean, he is saying that one fresh appeal memo is pending before the deputy commissioner, which is not yet decided, I think. I don't know as per him. Though the order of 710 was passed, as per him, it was passed ex parte. Ex parte or
Not
backdated order, as per him. So if the fresh appeal petition, as per knowledge of, from your knowledge, whether it is still pending before the deputy commissioner, this fresh appeal memo, is there any? Because
Lordship,
from the record,
it
it's
can-
definitely
it
it's
can
seen
be
that
seen that they have filed a fresh petition, but then they have filed it in
16,
16, Lordship.
16 October.
The hearing has already taken place in 7th, Lordship. The petitioner was present, Lordship.
Mm.
Then
No,
how it
that's
can be
why
pending
I am
again,
saying,
Lordship?
my lord,
On
my
his
sub-
own, maybe he have submitted another, Lordship, appeal that I'm
my
not
lord, if
denying.
the
Lordship.
order was passed on 7, my lord, why would I file and prefer a fresh appeal, my lord, on 16, my lord? My lord will see, my lord, on page 36 itself, I have the person who received, my lord. If your lordship would see, page 36, my lord, annexure 6, down below. Received on 22/10/2024 by Miss Yaro Mosu, who is the elder sister, man. This was served by the staff of the deputy commissioner. That's why my lord will say to determine this, my lord. My lord will call for the records. My lord will see whether any appeal petition was pending before the deputy commissioner on the 7th, my lord. Because this order was not passed on 7th, my lord. This is on 7th, my lord. Of course, it was a verbal, my lord. That's the difficulty, my lord. How the deputy commissioner, my lord, is acting, my lord. He has in fact implemented his decision not to take up the matter, my lord. That's why I came in the first writ petition, my lord. Now he passed this order, backdated order, my lord, after giving me time to file a fresh appeal, my lord. That's why I'm saying, my lord, praying, my lord. Let the records be called for, my lord. It will show whether there was any appeal, my lord. How did he decide the appeal, my lord? Because, my lord, the original is here, my lord. The first appeal, my lord.
That appeal is annexed in the writ petition also in 433. We have.
I
provided
have
that,
annexed in
Lordship.
the writ petition, my lord, but the petitioner was present before the deputy commissioner. That's why the petitioner is making a submission on oath that there was no appeal petition before the deputy commissioner on that day, my lord.
so 483 is against that order.
Yes,
And now 433.
433 is the first one, my lord, when the deputy commissioner refused, my lord, to take up the appeal, my lord. And 483 is the subsequent, my lord, writ petition, my lord. Just to frustrate the first writ petition, my lord, 433, this order, my lord, backdated order is in passed. I am repeatedly making submission, my lord. There, when the petitioner appeared, my lord, no hearing took place because there was no appeal petition, my lord. Orally, I was given time to file an appeal, my lord. Written appeal, my lord, press appeal. So I complied and filed on 16, my lord. It was duly received, my lord. And then on 22nd of October, my lord, after the fresh has been filed, my lord, this order was passed, my lord, backdated order. So that's why I'm praying, my lord. Let the records be called for, my lord. It will reveal everything, my lord.
So in 433, there is no need to pass any order separately, I think.
No, my lord. Yes, no.
483 will govern
483 will cover, my lord.
because 433 is the earlier
430,
petition.
there is already a direction from this court, Lordship, to dispose of the petitioner's appeal. So So that's why also Lordship, the Deputy Commissioner have taken up the matter, Lordship.
without an appeal petition.
483 to report, sorry.
Because my lord, the deputy
Mr.
commissioner under this act, my lord, is acting as a quasi judicial authority.
So Sophie, the learned counsel for the petition, and also have Ms. Nikki for the government advocate for the state respondent. Item number 3, huh? Item number 3. It's an application under Article 226 of the Constitution of India against illegality and validity of the order passed by the Deputy Commissioner Daporizu White DRJ /JUD -02/2024 dated 7/10/2024, whereby the appeal preferred by the petitioner was disposed of without any hearing. Next part, it is submitted by Mr. Soki that as per the in writ appeal number 433 of 2024, the appellate authority, that is the Deputy Commissioner, was asked to dispose of the appeal as per the provision under section 612 of the 2003 Act, which provides the appeal and the for an appeal before the Deputy Commissioner. But it was supposed to, but as per and no, but this appeal, I mean, this before, prior to that order 110, you again, the 110 order was passed by Deputy
By the
Commissioner?
deputy commissioner, directing me to appear on 7th, man.
Acha.
On 7th, I appeared.
Thereafter. But your appeal petition was earlier returned to you on which date?
17 September, my lord.
7th September. What is submitted by Mr. Sogi that he earlier, prior to filing the writ petition, he approached the Deputy Commissioner with an appeal on 17/9/2023.
24.
But same was not accepted, and the Deputy Commissioner was refused to take up the matter, and it was returned to the estate officer. Thereafter, when the petitioner approached this court, there was a direction to the Deputy Commissioner to take up the matter, and accordingly, the petitioner appeared before the Deputy Commissioner, and on my order dated 1/10/2024, the Deputy Commissioner was the petitioner was directed to appear before the Deputy Commissioner on 7/10/2024. But you have not appeared on 7/10.
I appeared, man. I appeared. That's why I am making the submission that there was no appeal petition.
So accordingly, he appeared before the Deputy Commissioner on 7/10/2024. But as per verbal instruction, but the Deputy Commissioner directed the petitioner to file a fresh memo of appeal, as the earlier memo of appeal was already returned to the petition, and hence he and accordingly, the petitioner filed a fresh memo of appeal on 16th 16/10/2024 before the Deputy Commissioner. But without hearing the present petitioner and on the backdated, the order was passed by the Deputy Commissioner on 7/10/2024, without even hearing the present petition. Accordingly, it is submitted by Mr. Soki that prayer by this, prayed by the Learned Council for the petitioner that the records may be called for as to see as to whether the appeal memo is still pending before the Deputy Commissioner and as to how the order was passed on 7/10/2024 without there being any appeal memo. Next paragraph, MS so submitted in this regard that from the order passed by the Deputy Commissioner, it is very much clear that the present petitioner was present before the Deputy Commissioner at the time of hearing and passing the order on 7/10/2024. And considering his unauthorized construction, which is not unauthorized, and considering his unauthorized construction over the government allotted quarter, his appeal was accordingly dismissed by the Deputy Commissioner. Next part, considering the entire submission made by the Learned Council for both sides, and considering the fact that and so, I find it proper to call for the records from the Office of the Deputy Commissioner as to whether the order dated 7/10/2024 was passed without there being any appeal memo. Till then, both the parties are hereby asked to maintain the status quo over the disputed over the property as per which, and when it was per the order 25/9.
25/9.
As per order dated 25/9/2024, passed in WPC 433 AP 2020. You need some time to produce the record.
Lordship, will need some time, but like what I have said is that it's a verbal submission of the petitioner that he
Obviously,
was
public
asked
submission,
to
but I am
asked to file a
yes, but I
press
am the
appeal.
point.
But then-
this is verbal submission. There is nothing on record.
Yeah,
That
there is nothing on
verbal
record.
submission.
Nothing
But
on
the question
record.
is that whether on that day, that is on 7/10/2024, when the order was passed by the Deputy Commissioner, whether there was any appeal memo was pending before the court. That has to be seen. Because as per him,
And
that
like,
appeal
Lordship,
memo
what
has
I'm
already
saying
been
is that
returned.
appeal memo was already there because we have sent the petition copy from here to the Deputy Commissioner. From there, he
As
can-
per the submission of the petitioner, the appeal memo which was filed earlier by him, that was already returned back to the petitioner or to the estate officer, refusing by the Deputy Commissioner. that
Original,
after.
I agree, but then Lordship, it is annexed in the writ petition, which we have forwarded to the Deputy Commissioner already.
Whether
We'll
the
see to it.
copies of the writ petition has reached there or not, my
Lordship,
sister cannot say that, my
No.
lord. On 7, when whether the copy of the writ
That
petition
will be
reached there,
based on 7th, when order was passed, whether there was an appeal memo.
my lord.
Because fresh appeal memo is obviously, it was a verbal instruction, there is nothing in the
My
record.
lord.
nothing.
So we are not on that. That is to see that let us call for the record. After 1 week, 2 weeks, any day,
2 weeks,
after 2 weeks.
Obligation.
obliged.
Item number 6.
Yeah, please, your lordship, this is a transfer matter, your lordship. To be fair, your lordship, I have already completed my tenure, your lordship. And so far as the other ground which I have mentioned is that in place of posting of the present petitioner, no reliever has been given. And then also the other is that basically medical grounds are there, your lordship. Unsympathetically humanitarian ground, your lordship. In regard to that, he has already approached by way of filing a representation before the secretary, respondent number 1, highlighting his grievances. The medical issues are really, it seems that it's serious in nature. And so far as the place where he has been transferred is at Yomi district, which is a very high altitude, which is detrimental to his health issue. And had any reliever would have been sent in my place, your lordship, I can understand that there must be some kind of public interest is there, but no reliever and I have has been posted in my place, your lordship. So at this stage, your lordship, I will propose your lordship to, with a direction, this writ petition may be disposed of with a direction to the respondent number 1, particularly respondent number 1, who has issued the transfer order, to consider my representation, your lordship. Highlighting entire medical documents and everything I have enclosed, your lordship. The
Where you have annexed the copy of representation?
lordship, I have already enclosed, which is at annexure 3, page 24, your lordship. The medical certificates are also enclosed here, your lordship. They have enclosed. It was filed on 25th September 2024, your lordship, before the respondent number 1. Along with all the medical.
You are not being released till now.
Uh,
reliever is not-
lordship, I have been released.
Oh, you have been released.
Released.
And then,
Released. I have also enclosed the released order.
and you have joined your new place of posting? Already you have joined?
No, no, lordship. In my place, no, a reliever has also been sent. I have learned that he has already been assigned for some other duty also. He is a football coach, your lordship. The release order has not been given into effect.
Not been?
Not been given into effect. He is still presently posted at the in the present place of posting.
In his place of earlier posting.
Lordship. Finally, see, your lordship, the transfer order is at page 22. Shri Koya Yame is the petitioner who was working as in charge district sports officer in East Coming district, is repatriated on transfer and posted in the Shiyomi district as football coach with immediate effect. But in my place, your lordship, no reliever has also been posted, your lordship.
This is order pertains to whom? This order is
Me, your lordship.
for you.
Yes,
Acha.
only to the extent of petitioner only, no reliever has been served in my place, your lordship.
So you are a football coach
Yes, your lordship.
and you have some medical
I-
issues also. How?
Lordship,
If you are a football coach, how you can have some medical issues?
lordship, medical issues are there, your lordship. There are certificates has been issued.
Then
Doctor's prescription, along with my wife, your lordship, she is also not. I have a small children who are also studying there during the mid-academic session. If the transfer order is given into effect, your lordship, the academic sessions of the children will also suffer, your lordship. That is as per the guideline, your lordship. Circular, the government of Arunachal Pradesh issued one circular. In that circular, they have to take care of the students' academic and then medical issues and all also while transferring, when a representation is filed, your lordship. I have challenged this release order also, your lordship. I have challenged this also. I have challenged this interim transfer order as well as the release order both. Pursuant to this, I have submitted representation. And as per circular, your lordship, page 28 is the typed copy of the circular. Last, as per para 3, the procedure to be followed is indicated below. The transfer posting order shall be issued by April, that is immediately after the financial year ends, so that implementation of plan schemes and budget expenditures are not affected by such orders. The officers so posted transfer shall take charge of their respective places of posting by May, and that is before the onset of the monsoon and after the school examination of their children. I have enclosed this also, your lordship, the certificate of my minor child, your lordship. Is at annexure 9, page 62. medical certificate of the petitioner along with his wife and elder brother, Your Worship. Is at from page, which starts from page 32 to 60.
Okay, yes.
Lordship will see in the annexure one itself, Lordship.
Annexure
He
one.
cannot challenge the release order also. He is not a regular DSO there, Lordship. He's in
No,
charge,
I'm-
Lordship. And
I'm-
he have stayed long enough, Lordship. The already more than
That Lordship,
Well,
I have
it
fairly
accepted already.
submitted, Your Worship.
more than 3 years, Lordship. And this was issued in 10th January. Now he's
No, Lordship,
now finally is taking giving effect to in September, Lordship. And Lordship, the employee, government employee, they cannot always take the Lordship hardship of the kid, school going children, Lordship. If everyone says that, Lordship, then so it's
Can,
not a case that he's being transferred in Lordship. Medical condition, Lordship. Nowadays,
Lordship,
If
representation
test
is pending.
Nobody test is taken. Blood here and there, this thing here and there, everything is always there, Lordship. It will be there with everybody, Lordship. It's, I don't want to say that it's not a Lordship.
So he was
Serious lordship,
posted in his
illness.
present, that post place since last 3 years. So he has completed his tenure.
Lordship, I have admitted, Your
You
Lordship, I
admitted
am
already,
fairly
yes.
submitting, I have completed my
Then,
tenure, Lordship. In
There
regard
is
to that, I have
no
completed.
reason, Lordship, no reason to interfere.
And so far as I have submitted my represent, kindly see, Your Lordship, transfer order was issued
He
on
wants
10th.
to say that there may be direction to the respondent number 1 to dispose of his representation. That much only.
At
It
this
is
stage,
considered, we are not going to interfere in any way. But the question is, one representation is still pending.
Lordship, that much only.
That much
because,
only.
Even
That
the,
representation,
it is
it is
passed from
really
the
can be
regular
considered, it can be or otherwise, because
yes,
I know the medical issues, etc., will definitely come for everyone.
yes. yes.
I have.
Unless there
I
is
have
some serious
problem.
illness, Lordship.
Yes, yes.
serious
And
I don't,
illness,
there's
I
some
don't want to
illness.
say this, but I don't want to say this, but I'm sorry. Still. This is some test here and there only. Lots of time.
serious, his younger brother is really very serious at the last stage of his life, Your
No,
Lordship.
I'm not saying about the family
Yes, yes, I
members,
agree.
brother. I was saying.
And that I have, although the release order has been given, but that has not been given into effect, Your Lordship. And moreover, Your Lordship, in my place, no reliever.
Mr. AKC, the learned counsel for the petitioner, and also heard Mr. Insu, the learned government advocate, senior government advocate, for representing the state respondents. This is an application under Article 226 of the Constitution of India for issuing a writ in the nature of certiorari, public and oral mandamus, and or any other appropriate writ, order or direction. By this present writ petition, the legality of the order order number DSYH ESST 69 03 dated 10/1/2024, issued on 16/9/24 by the Secretary of Sports, Government of Arunachal Pradesh, Itanagar, transferring the present petitioner from and as transfer this petitioner as in charge district sports officer, East Cumming District, and posted at SI and SC Yomi District as football coach without posting the reliever at East Cumming District in place of the petition. However, the release order was issued on 18/9/2024 by the respondent state authority. Respondent authority. It is the case of the petitioner that
On 22 September 24, he has submitted representation, which was
that
received
after
on
the
20.
order of the transfer order and the release order. After release order only you have filed your representation.
Yes,
Your
sir.
release order was
On 25 September, the release order is at 18 September 2024.
and your representation is of 25th of September.
Yes.
So and so. However, after the release order, he filed a representation before the concerned authority for cancellation of his transfer of the posting order and for retaining him in SEPA in East Cumming District as DSO IC REG. It is submitted by Mr. Singh that the present petitioner basically present petitioner had to file a representation before the concerned authority as he is facing some acute domestic and medical problem and mentally disturbed. He is also a type 2 diabetic patient. And apart from that, your younger brother, no?
Lordship?
Your wife is also suffering.
Yes, Your
His
Lordship.
wife is also suffering multiple disease, and his brother is also suffering from chronic liver cirrhosis. And they are undergoing treatment, and for which his presence in the house is very much essential. Further, he submitted that there is none to look after his only son, and what is it, bedridden parents. So basically, on the medical grounds, he filed a representation before the concerned authority on 25th of September 2024, but the representation is still pending before the respondent number 1 and 2, which is not yet decided. Mr. Singh further submitted that though this release order was passed on 18/9/2024, but no reliever was posted in his place, and this order of release is not given effect to that. Next paragraph. MS so government advocate submitted in this regard that the order of transfer was dated January 2010 and 10/1/2024. However, it was issued on 16/9/2024. In spite of having knowledge about the transfer order on 10/1/2024, the petitioner did not file any representation before the authority concerned, and the order of transfer was passed only after completion of his tenure for 3 years in his present place of posting. Accordingly, there cannot be any reason for retaining the present petition in his place of posting, where where release order has already been passed by the authority on 18/9/2024. Considering the submission made by the counsel for both sides and after perusal of the entire case, the present the petition is disposed of at the motion stage with a direction to the respondent number 1 and 2 to dispose of this representation filed by the petition dated 25/9/2024. With that observation, then disposed.
All right.
Lordship, till the disposal of representation, Lordship, at least.
No, sir, nothing.
Time may be.
No. Since already release order also.
It's already released order.
And that has not been. Item number 7.
Hey,
May I please, your lordship?
Item 7.
May I please, your lordship?
Yes.
Matter pertaining to transfer. So I am the junior health assistant working at Pakekesang Community Health Center PHC under DMO Pakekesang. So I have been transferred to Anjao. Anjao is a quite far away from here, near China border. So I am not in the position to join in my new place of posting as I am under treatment. I've been suffering from alopecia, that is hair cancer. It is disturbing me. And moreover, I am on burden of my old ailing parents, 90 years blind mother. So my children are also school going. They are now in lower primary school. So these are my problems, especially on health ground. The situation is not permitting me to join. So I have filed on representation. My transfer order was passed on 18th September, but it was not known to me. But when release order was passed on 18 October, then along with release order, my transfer order release order both together, I happened to receive in the last week of October. So immediately on 18, as and when I received the release order, I have filed one representation on 19 of this month, 19 of October. So still there is no attendance, no reply of my attendance. So at present, I have approached this before this honorable court, having no alternative to stay my transfer. So, my lord, I am suffering from this serious disease. So RK Mission Hospital, my attending doctor suggests me to keep on visiting frequently for treatment or for checkup. So Anini is so far away. It is 500 kilometers distance from this Pakekesang. So in the year 2021, I was transferred from Kurungkome with my request for attending my blind mother at Pakekesang. So still my mother is alive, half deadly. So it's my burden to look after her also. So this is the issue. So presently I am unable to join in the place. My transfer order is page 16, Lordship. Annexure page 16 is my transfer order, which was passed on 18 September of 2024. May I read, madam? In the interest of public service, Sri Tara Tana, I am Tara Tana, health assistant, junior health assistant, is hereby transferred from CHC Pakekesang under DMO Pakekesang AP to Anjao under the establishment of DMO Pakekesang. So under DMO Pakekesang, which CHC, I will have to attend. That is also not mentioned, but I am at any rate, I am not capable in this situation, the Lordship. So again, this release order also issued. It was unknown by me. It was not enlightened in my knowledge that on 18 September I was transferred. But while I received the release order on 18 October, then only I came to know that I have been transferred to Anjao. And immediately I submitted one representation requesting the respondent authority, that is respondent number 2, Director of Health Services, at least to consider my transfer. Had I been transferred to Zero or nearby Yasuli, Sagali, etc., then I could have, because I can attend my mother also, and I can visit Ramakrishna Mission also after attending the new place of posting also, if it is 1 day journey. But Anjao is too far, my lord. So for the medical ground, I earnestly requested the authority, but my representation is not attending till that. So right now, the transfer order may be stayed.
My lord, since the release order has already been issued, my lord. Now, once the release order is issued, my lord, even his payment, salary, it cannot be prepared. The entire or relevant has been transferred to the concerned DMO, my lord, in different district, and they have a different treasury officer, and the salary, even the entire relevant record has been sent, my lord. Practically, at this stage, my lord, it will have, but it's not possible since entire he's no more the staff of the DMO, the Pakke Kesang now, as his entire relevant record, service record and last pay has been already transferred, released. So at this stage, man, what we can do is at least his representation can be disposed of. Otherwise, there's no way out.
This everything transfer, it was in dark of my mind because it was not informed, nowhere whisper. Even I'm attending regularly in the office, but still not whisper
It
before.
was in dark and the transfer
It's
order was
injustice. It's a politically motivated transfer.
I have some problem, you have some problem.
Yes.
That has to be.
Yes.
If you are in service, then
Yes. Authority will consider this aspect.
service condition. Heard Mr. Udeka, he done it from the petition.
At least till the final disposal of my representation,
Mr.
transfer may be stayed, Lord.
Planning Council for Department, representing the state respondent number 1, 2, and 3. Same, you can write, this is an application, so and so. Is there any frequent transfer? You are posted there since 2021. It cannot be a frequent transfer, na?
Yes.
Since 2021, you were there,
21.
then
The time period, the limit,
period has already
it's already expired.
Mandatory
2
period,
years.
but on my health ground, because situation, my
what to
health
do, or health is
not
there
permitting me.
challenging the legality and validity of the transfer of the petitioner. Issued by order number MEST dash 2019 oblique 846 bracket of PHE dated 18 September 2024, and the release order issued by District Medical Officer DMO Pakke 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 Kesang by number MEST dash 05 oblique 2019 says 226 dated LEMI dated 18th October 2024. It is submitted by Mr. Deka, Learning Council for the petitioner, that he was not aware about the transfer order issued against him on 18th of September 2024. And he came to know about his transfer order only when he received the release order dated 18 October 2024. Immediately on receiving the release order, he filed a representation before the department concerned on 19/10/2024 to consider his to consider his to consider the to consider his or to stay his transfer order, considering the health issues of the present petition, who is suffering from. You are suffering from what?
Alopecia, Lordship, alopecia. This is page 21
Alopecia.
is my disease given. So alopecia, doctor prescription 20.
Hair cancer. Hair cancer.
Hair cancer. Hair cancer.
Suffering from hair cancer, and he is regularly visiting RK Mission Hospital at Itanagar from his place of, and it is manageable. It is a manageable distance from his present place of posting to attend the hospital at RK Mission at Itanagar. But this, by the transport order, he has been transferred to Anjao, no?
Anjao.
Anjao, which is quite far from his present place of his place of residence, and it is may not be possible for him to attend the hospital for his treatment. Moreover, he has the burden to look after his whole ailing parents, and there is none to look after his whole ailing parents. And considering all these facts, and with all these facts, especially on the medical ground, and with all these facts and especially with the medical ground, he filed his representation for the authority concerned, but his representation is not yet attended intentionally by the authority. However, till date, no reliever has been, there is no reliever, your reliever is not there.
No, not yet.
There is no order of reliever for his place of posting, and hence he prayed for stay of his transfer order till disposal of the present petition. Next, in this context, Mr. Thakur, the learned standing counsel, Health Department, submitted that his release order has already, the order of release has already been issued by the department, and hence his entire records of the service records, etc., were already transferred to his new place of posting, and hence the department is not in a position to pay his salary and etc. from his earlier place of posting. More so, the transfer order was made after completion of his tenure of 3 years in his present place of posting. After completion of his 3 years, tenure of 3 years, and hence the authority is not in a position to consider his prayer for stay or retaining him in the earlier place of posting. Next, considering the entire submission made by the Legal Counsel for both sides, a matter to dispose of for at the motion stage, to directing the authority concerned to dispose of this representation.
Obliged.
No more.
Well, challenging the impugn seniority least at page 59. Before that, since I'm on a small interim prayer, let me highlight my case. Well, I was recruited in the department of PWD as a junior engineer on 30/10/2008. And that my lord will find at annexure 1, page 25 to 28. Just I'm giving the date. Then on 23rd August 2012, my service as a junior engineer was confirmed. Then what had happened on 31/12/2013, I was transferred to Department of Urban Development and Housing. And that urban development and the housing department, is a department that was a nodal department for the nodal department which were controlling the cadres of IMC municipality corporation employees. So that was on 31/12/2013. Then on 3rd January 2014, my lord, I joined the department. And thereafter, I was transferred to Pasigat Municipality Council, my lord. Then what had happened is on 6/1/2014, my lord, I joined there. And 15/7/2016, the private respondent who was serving as APO RE, my lord will find at Annexure 7 that particular thing, page 32, my lord. There he was selected. He was also taken on deputation, and his substantive post was junior engineer. So then what had happened, my lord, on 24/2017, he joined under me as a junior engineer. The petitioner was already a serving assistant engineer, my lord, in the IMC. Now what had happened, after lapse of 10 years, my lord, I was not given absorption at all, my lord. So finally, after a protracted battle, both inside the court and within the department, my lord, then finally I was absorbed. I was absorbed on 17/1/2024, my lord. That, my lord, will find it page 57. Now, what had happened is, my lord, in the meantime, my lord, on 31/2024, my lord, the impugned seniority list was published. That my lord has seen. My lord, kindly come to page 57 for a moment.
Yes.
Here, my lord will find consequent upon the acceptance of consequence upon the acceptance of option exercised by the following junior engineers for absorption in the Department of Urban Local Bodies, and on the basis of no objection certificate issued by parent departments, the Governor of Arunachal Pradesh is pleased to absorb permanently the following junior engineers in the Department of Urban Local Bodies as assistant engineer in the interest of public service at their existing scale of pay and service benefits as per shown below, my lord. With all consequential financial and service benefits. My lord will mark this. With all financial and consequential service benefit. So that means what, my lord? My past service has to be counted for finalizing the seniority, my lord. So, my lord, kindly see that there is a judgment called, well, just I can place it also in your book. It's okay. Well, there is a that I'll rely that my the learned additional AG also knows. That judgment, particularly that Ruplal judgment is there. The 2001 4 SCC, my lord, page 664, para 23 and 24, my lord. I'll come to that proposition for a moment, my lord. So now what had happened is, my lord, now this impugned order, as my lord has seen that at page 57, my objection was that the word, the Governor of Arunachal Pradesh is pleased to permanently absorb the following junior engineers with all financial and consequential service benefit. The word consequential service benefits would mean, my lord, exactly sits on the top of the ratio laid down in the SI Ruplal judgment. And latter part, my lord, in Mirgang Joshi judgment also, 2017, that judgment SI Ruplal was reiterated. Yes, if a particular officer is brought on deputation and absorbed, with two conditions, my lord. One, the first absorption, the condition of the absorption would be that, my lord, the first, okay, from the date of absorption. Otherwise, with the retrospective effect, my lord. So in my case, my lord, in 2014, my lord, I had to, 3rd January 2014, I have joined the Municipality Corporation as assistant engineer, while these private respondent number 3, my lord, joined in the year 2017, my lord, as a junior engineer, and he was under me. Now, my lord, with this impugned seniority order, my lord, seniority list, my lord, they are going to proceed for a departmental promotion committee. So now in that event, my lord, in that event, what happens? My engineer will sit over me. Then, my lord, that 1997 for SEC, there is one judgment, RK Sethi versus ONGC. In that, even the situation that I anticipate is, my lord, what happens is, if your junior is given a promotion, then what happens? If I come back to the department, then they have to create, there's a concept called supernumerary post, my lord. They have to create a supernumerary post and has to place me. That is a paper promotion. Then my seniority will also be gained. Now, my lord, another judgment is 1982 supply, my lord. That's called Maharashtra Direct Recruit Engineer Grade 2 judgment. In paragraph 47, it is not with me, my lord. In paragraph 47B, it has clearly held, that is 5-bench judgment, constitutional bench judgment, my lord. It says that if the particular officer, the recruitment is in accordance with the law, and if he has come on deputation from one department to another department, his past service will be counted for the purpose of seniority and pensionary benefits. It is no more res integra in service jurisprudence that past service of a particular officer has to be counted. So here, my lord, we kindly come to this page 59, my lord. Page 61. 61, my lord, will come to 61, page 59, my lord, sorry. This is 30th January. The final seniority list of assistant engineer. The provisional inter-state seniority list of assistant engineers of urban local bodies was circulated to all concerned by notification number so and so, inviting their claims and objections, if any, and submit the same within a period of 1 month. In response to the above mentioned notification, the assistant engineers of urban local bodies, ULB, submitted a representation communicating that they have no claims and objection against the provisional inter-state seniority list of the assistant engineers circulated to them. Therefore, the final inter-state seniority list of assistant engineers of the Department of Urban Local Body is hereby published for circulation to all concerned as indicated against each of them. Now, my lord, I am concerned with the serial number 3, my lord. The 2, I am not, they are senior to me, I can see that. My lord has seen that gentleman, private respondent number 3, has joined under me on 15/7/2016 as a junior engineer. My lord will find that at page 32. That is what. So now my lord will see, then again, in the backdrop of this and being aggrieved, I have submitted a representation at page 61 to the Commissioner, Urban Local Body. Now here, my lord, I have given this particular representation with this following background, my lord. Objection of subject, my lord, it dated 21st August 2024. Subject, objection of inter-seniority list of assistant engineer urban local bodies, ULBs, white, so and so, so and so. Literature of, my lord, the engineers are too poor sometimes when I read this. Respected sir, stroke madam, I would like to draw your benevolent attention on the fact that the inter-seniority list of assistant engineer of urban local bodies, ULBs, has recently been listed out without any intimation and acknowledged to me. Now, my lord, it is very clear. My absorption was on 7/1/2024. This final inter-state seniority list came out on 31/2024. That means 14 days after my absorption. I ought to have been given a fair opportunity of placing my grievances before the authorities. And then it says, now next, that sir, the NOC for any claim and objection which was earlier served from the higher authority prior to list out of the state seniority list was never received to me till date and lately appears to have never existed. The allegation is serious, my lord, if there's 2 lines. Here I also mentioned that Engineer Baman Sanjay, who is my junior, was assigned as my junior engineer under Naharlagan South Division IMC in 2017. Appointment letter was enclosed, my lord. There's no doubt on it. It is noteworthy to mention that undersigned is the first assistant engineer to be posted in the ULBs and have good number of years as working experience in this department, which is a prime requisite factor in this seniority list. However, the recently issued interstate seniority list has resulted in junior officers being promoted over their senior counterparts, thereby depriving the senior officer of their rightful advancement opportunity. So that particular prayer portion is always there, Milord. So therefore, Milord, kindly come to my prayer portion that a small, Milord, as of now, my instruction says, Milord, the department, there are vacancies of the executive engineers. Now, on the basis of this impugned final interstate seniority list, they are going to promote it. Now, therefore, Milord, kindly come to my prayer at interim prayer at page. This quashing and setting aside is always there, Milord. Mandama secretary is there. But page 21, Milord, will kindly come in the interim, Milord. Page 21, Milord. In the interim pending disposal of the rule, this honorable court may be pleased to stay the operation of the impugned final seniority list of assistant engineer, notification being memo number so and so dated 31/2024, issued by Commissioner ULB Government of Arunachal Pradesh till final disposal of the case, and or further interim order may please be restrained from holding of DPC for promotion to the post of regular executive engineer on the basis of the impugned seniority list of assistant engineer. Well, as of now, I have given a two proposals. First, Milord will stay, or if not, Milord, the second option is that Milord will kindly restrain them from holding the DPC for promotion of assistant engineer to executive engineer on the basis of this impugned interstate final seniority list. Only in respect of private respondent number 3, we are giving leeway to the free hands to the government to do DPC, because I cannot claim over the seniority of my seniors, those who are at serial number 1 and 2, Milord. So, my Lord, as prima facie, I have demonstrated my case, Milord. That much, I don't know what additional AG will submit.
My Lord will kindly come to page 48. Page 48 is the promotion order of the private respondent. This is dated 7th August 2020. I don't require to read it, madam. This is the promotion order of the private respondent. 7th August 2020, from the post of junior engineer to assistant engineer. Meaning thereby, on 7th August 2020, the private respondent has become an assistant engineer, regular assistant engineer of the department. Now, my Lord, at page the impugned page 59, my Lord. The seniority list, my Lord. My Lord will kindly see the provisional interstate seniority list of assistant engineers of urban local bodies was circulated to all concerned by notification number so and so dated 9/5/2023. Provisional seniority list 9/5/2023. This was circulated, inviting their claims and objections, if any, so and so. My Lord, that provisional seniority list of 9/5/2023, I believe in that provisional seniority list, the name of the petitioner will not figure. And it could never figure because she was still not born in the department. she was still on deputation. This is the final seniority list. On the basis of that preliminary notification of inter-seniority.
Okay.
Provisional seniority list. Her name could have never figured because she was never in the department. Now, therefore, basing on that, this final seniority list has come up, my lord. Now, my lord will see the absorption order of the petitioner, my lord, at page 57, my lord. She has been absorbed only on 17 January 2024. Meaning thereby she is born in the department on this day, on this 17 January 2024, my lord. She has become a regular employee of the department. And what it says, my lord? Consequence upon the acceptance of options exercised by the following junior engineers for absorption. Following junior engineers, although they were holding the post of assistant engineers, but their substantive posts were junior engineers in their parent department. They were on deputation as assistant engineers. They are not regular assistant engineers. The following junior engineers for absorption in the Department of Urban Local Bodies and on the basis of the NOC issued by parent departments, the Governor of Arunachal Pradesh is pleased to absorb permanently the following junior engineers in the Department of Urban Local Bodies as assistant engineers in the interest of public service at their existing scale of pay with immediate effect with all consequential financial pay protection and service benefits as per details shown below. My lord will see last date of absorption. This date of absorption is 17/1/2024. A deputation becomes a regular employee of the department from the date of absorption. On 17/1, she became the regular employee of the department. Now the question comes, whether her past service in the parent department will be counted for claiming seniority. Now, in this context, I differ with the submission made by my learned friend, my lord, because the past service should be in an equivalent post, equivalent grade. SI Rupral says, if you have served in an equivalent post, the past service will be counted. But here, she was serving as a junior engineer, which is not an equivalent lower post, my lord. Now she is being absorbed as an assistant engineer. So her past service as a junior engineer will not be counted for claiming seniority. She becomes an assistant engineer only on 17/1/2024. And as shown earlier, the private respondent was an assistant engineer in the year 2020, my lord. So, my lord, I believe this entire writ petition itself is misconceived. The service in an analogous post in the earlier parent department, that can be counted, not a lower post, not a service of the lower post. That is the proposition in SI Rupral case, and that is a settled point. Otherwise, it will be the deputationist will be counted, the seniority of the deputationist will be counted only from the date of absorption. cannot claim the past service until and unless it is analogous. Equivalent and analogous. That's what. So this petition does not call for any interim order at this stage. Let notice be issued, my lord.
Lord, I'm pressing for the interim and I have the liberal right of rebuttal, the submission made by the additional agency. In the first place, Lord, somehow, somewhere, the famous English proverb says, or something in a very casual manner, don't get offended, that normally we quote, my lord, as a prank or sometimes on the hilarious or something more. Now, making a window shopping in the castle of Chinatown. Probably, since the learned additional AG has used the word, then this read petition is misconceived. Probably, somehow, what I feel is the learned additional AG was doing some window shopping, most probably, my lord. But that window shopping is, my lord will find here. Kindly come to page 29, my lord, for a moment, my lord. Well, let us see, I was transferred with post with the main power by this order, my lord, 31st December. My lord. Then, my lord will kindly flip over to page 33rd December. Here, again, my lord, as I made the oral submission, my lord, I did not write on this. Then, permanently see, my lord, in the urban development department, my lord, that was the cadre controlling after the town and urban local body department was created, my lord. So then, in engineer also, my entry is senior to the private respondent. We are not challenging his illegal appointment because the law says that you cannot sleep over in the service matter. The longest delay that you can take is only 6 months. Then the delay and laches doctrine will come and then the waiver will come. You know. So now, my lord will see, kindly see, then I was posted as this is my substantive post, my lord. That means before the private respondent joined the department, I was already senior. Now in service jurisprudence, law is well settled that without there is only one norm in service jurisprudence, without considering the case of senior and promote the junior will be violative of Article 14 and 16, read with 309 of the Constitution of India. So on this proposition also, I fit senior to the private respondent. 3. Now, my lord, see, kindly see, I have joined here, page 31, my lord. Page 31, I have joined as assistant engineer, my lord. 2014, my lord. It is not a case, my lord. 2014 onwards, I have been working as assistant engineer until the promotion. The manner, my lord, we can see on 17, my lord, I was given permanent observation. You have used the word, my lord, that I have particularly indicated, my lord, the word with all consequential pay and service benefits. Now, once you use that with all consequential and past service benefits would mean what? My rights accrued from 2014. It is there, law is settled. He also knows. The learned additional age, he also knows. So therefore, then what happens thereafter? I was transferred to Itanagar, Municipal Corporation. So then kindly see, here, page 32, 34. My lord will kindly come to page 34 for a moment. Joining report 37. Well, 37 is my joining report on my transfer. This is how the private respondent came as junior engineer. Now the question comes, my lord. Somehow, somewhere, there was a proliferation of mindset to favor this particular private respondent number 3 by the authorities. And then they cannot go away from the mischief they have committed. So therefore, my lord, nothing is going to happen. Or my lord alternatively will issue notice, returnable 3 weeks. Let them file the affidavit in detail. I'll take dusty service as well. And my lord, any further DPC with on the basis of the impugned seniority list shall be subject to the outcome of this rate petition.
Yes, ma'am. I agree to that. Any DPC shall be subject to outcome.
Subject to outcome of it. Cannot proceed.
Heard Mr. Chitti Tara, the learned counsel for the petitioner.
Yeah.
And also heard Mr. Edmonton, the learned additional agent for the state respondent.
I am not.
Yeah, for the respondent 1 and 2.
I brought it.
The decision of applications under Article 326 of the Constitution of India. Calendar day. Directing against the order number SUDH 11/54 2023 SUDH UDH dated 17/1/2024 by which no. Sorry. Challenging the legality challenging the legality and validity of impugned finance seniority list of assistant engineers. Right, memo number SUDH 13/2023 SUDH UDH dated 30/01/2024 issued by the Commissioner ULBS, the Government of Arunachal Pradesh, Itanagar, wherein the name of the private respondent number 3 is reflected in the serial number 3, indicating that she is senior to the present petitioner, who is actually junior in service, and this classification is illegal, arbitrary, and discriminatory. As it fails to account for the petitioner service from the date of joining of the Department of Urban Local Bodies. It is submitted by Mr. Tara that the present petitioner was appointed as a junior engineer in the year So you joined as a junior engineer in which year?
2007, I am sorry. 8, my service was confirmed.
8.
Yes.
Was joined in the year 2008 or 7, and her service was confirmed in 2008. However, White order dated 13/3/1/2014. She was deputed. She was under deputation as to work as an assistant engineer with immediate effect. With the immediate effect till such time the municipality requit his own cadres. The private respondent number 3 joined under her in the year 2017, no?
Correct.
In 2017 as a junior engineer,
20th April 2017.
13 April 2017. But your your absorption order is at page
Page 57 on 17/1/2024.
57. And by order dated 17th January 2024, the present petitioner was absorbed as a assistant engineer in his service from since 17/1/2024, wherein she was also given the all consequential and financial benefits of her service of her past service. However, but without considering this aspect of the case and her seniority, the department has issued a seniority. It was 59, no? 60.
Correct.
Your seniority list is at page
8 page 59.
59.
That
But
is
as per
30.
the but by notification
No,
dated
59.
it was published on 30
January
30.
2024. 30.
3/01/2024, whereby the name of the private respondent number 3 is shown in the number as number 3 in the seniority list without any information or intimation to the present petitioner, who is senior to the private respondent number 3. And
And my representation is page
61.
Yes.
Thereafter, she also filed a representation before the authority concerned on 21st of August 2024. That was not considered.
That was not.
That till now.
My lord,
Till now, it is not rejected also.
Not rejected also.
But till now, the state representation is not considered by the
Not
department.
rejected.
Nor she is intimated. No, consult so and so post. And accordingly, it is prayed by Mr. Tar that the notice may be issued to the private respondent. However, till the final disposal of the present petition as an interim, the operation of the said impugned final seniority list of the assistant engineer by notification of being memo number SUDH 13/2023 SUDH UDH dated 30/01/2024 issued by the Commissioner Government of Arunachal Pradesh may be stayed till final disposal of so and so.
My lord,
In the alternative, alter pair is also there.
yes.
Another, the alternative, another interim pair to restrain from holding DPC for promotion to the post of regular executive engineer on the basis of the impugned final seniority list of assistant engineer.
Only in respect of respondent number 3.
Only in respect of the respondent number 3. Next one, Mr. Ratan. The learned additional PP additional AG submitted in this regard that the present petitioner was absorbed as a regular assistant engineer only 17/1, I think, no?
17/1/2024.
As only 1/17/1/2024, whereas the private respondent number 3 was
Regularly promoted on
regularly
7/8/2024.
7 regularly promoted to assistant engineer on 7/8.
Yes.
7/8/2023.
It's a 10/8.
7/10. That's
It's not down below you. No, no, you need to switch from it. It's not different. You have to put it. It's not like that.
Definitely differently. More so, the circular, more so, from the notification. More so, the notification dated 30/01/2024. It also requested the provisional inter-state seniority list of assistant engineer of urban local bodies was circulated to all concerned by notification number SUDH/13/2023 SUDH/UDH/152 dated 9/5/2023, inviting their claims and objections, if any, and to submit the same within a period of 1 month. But within that period, the present petitioner did not file any representation or objection before the authority concerned to consider her application. Next, considering the interest submission made by the council for both sides, issue notice to agote kore dibo na agote issue to notice kore dibo. Aspects of the matter, and for ends with justice, I find it justified to after hearing so and so, the respondent authority is hereby directed to file is asked to file their affidavit in opposition, if any, on or before next date of listing, and the learned counsel and the petitioner will also take steps on the respond number 3 through register post as well as through dusty service, and the affidavit will shall be filed to that effect of service of notice through dusty mode. In the interim, want to say the DPC.
Any DPC shall be subject to outcome of this writ petition.
The interim DPC shall be subject to the outcome of the outcome of the present petition.
In respect of
In
private
respect
respondent
of the
number
respondent number 3.
Let us make it clear.
Yes.
List after 2 weeks or 3 weeks?
3 weeks, ma'am.
Well, may I request one more line to be added in the interim, pending disposal of writ petition shall not be bar upon the state respondent to dispose of the representation as so filed by the petitioner, which is at page 761.
Pending disposal of the petition, the authority concerned there will be no bar to the authority concerned to dispose of the representation filed by the present petition.
By a reasoned and speaking order.
Obviously, speaking order.
Yes, grateful.
Okay.
My senior counsel is mentioning in VC lordship.
Huh?
The consent has been taken from respondent side lordship.
Your
Maybe
senior
list after
counsel is?
2 weeks lordship.
No, what you said, your senior counsel is?
Mentioning in VC lordship and Duncan lordship.
This is also a matter of 2020, no?
Yes. Oh, that's it. But this person has already retired. He's seeking promotion.
Already retired.
Yes.
Matter is of 2020, he already got retired. The request made by the Learning Council for the petition. With the consent of the other side, the Learning Council for the petition made a request for adjourning the matter, stating that his NBS council, who is your NBS council? Senior council?
I on behalf of N. Duncan Lordship.
And Tagu. His BD otherwise by law. Not in a position to attend the court for argument. How many weeks then you want?
2 weeks, Lordship. After 2 weeks.
List accordingly after 2 weeks. Okay.
Infield, Lordship.
What's it? I'm deeply apologize for the inconvenience. For prepone of date.
আমি তো নোৱাৰো possible নহয় তেখেতক ফটো দিব পৰা যায় নেকি ভোটাৰটো দিব নোৱাৰি কোনো তেখেতে আপুনি হেৰি মিলাই দিব পাৰে আমাৰ ৰেজিষ্টাৰত তেখেতে ভোটাৰ দিব নোৱাৰে অলৰেডি ভোট ফিক্স কৰা আছে তাতে একটু possible নহয় মোবাইল you want 7
years.
Other 7 কোন আছে সব
What is the item, sir?
Yes.
Item number?
Item number 4 and 5.
Who's the dictation? Who does it? 4 and 5. It's who knows it? Yes, already date has been fixed. Now he is saying that it will become otherwise infructuous.
Infructuous, my lord. Because authority concerned.
Date is on 8, fixed date is on 8, I think. As per him, I don't know.
Otherwise also, the petitioner who earlier occasion paid municipal report by petition. And same was disposed with direction to file a representation. They filed representation. Again, they withdraw their representation. Now they are coming and said that he have not put his signature in the representation. All such allegation we cannot keep in the.
That is the allegation that has to be ascertained on the 7 lawsuit. That's why. Otherwise, entire merit petition will be infructuous.
What is the date fixed on 8? In fact, 8 is on
8 is for opening of the financial bid. Let the matter, if there is no merit in the case, let the matter be disposed on the 7 lawsuit.
Otherwise, madam, their grievance is regarding the proposed road is going to pass through their private lands. So nothing will affect that if the road does not pass through them.
So 7 we are fixing. Let us see if it can be reached or.
I deeply obliged. Deeply obliged.
My lord, may I pray that the item?
Also, sorry, 9.
My lord, may I pray that the matter may be passed over for a while, your lordship. Mr. Pangling is on legs in video conference.
Okay. For time being?
For time being. Much obliged.
May it please your lordship. I was pursuant to a tender. I was awarded a work of construction of bridge design in it's an EPC contract. That's engineering procurement contract. The NIT, my lord, is from page 26. So lordship may not go through the NIT. It's for the work of subsoil investigation, design, drawing, and construction of 80-meter span major permanent shared Thapa bridge over so and so Nala, approach road so and so in EPC mode. My lord, the letter of acceptance is on 14/3/2022, page 28-29. I'll not bother lordship with that. Just a brief synopsis of the issue here. Then we entered into an agreement From page 34, 36, the agreement is there. My lord, we started the work, but there was some issue. Issue in the sense that the local people, they claimed the land and through which the road is to be constructed and the bridge to be done, my lord, was theirs, and they were seeking land compensation, for which we could not carry out the work there at that time. In fact, I have informed the authorities. If my lord comes to page 45, 44, I have sent the email. 45 is the document. With reference to the above cited subject, I am unable to proceed to worksite with TNP and laborers. As some local people who claim to be the landowner of the said worksite warned not to start the work unless land compensation issues are resolved. The following persons are as follows. Well, that's so and so I've given them. That is why I could not proceed with the work on time, because the land and my lord knows it's in the China border. My lord knows what actually goes on there. So I could not proceed. And thereafter, it's a construction of bridge, my lord. There was an earlier Bailey Bridge near the site. Due to floods, my lord, that bridge, it got washed away due to heavy floods and landslide. It washed away and was deposited in the site where I have to start the work. So after even the land compensation issues were resolved, my lord, because of the deposit of that particular old bridge, old Bailey Bridge, I could not carry out the work. I informed the authorities of that. My lord, and my lord knows in the monsoon season, right from April onwards, because of floods, landslides, the work of bridge construction in high altitude areas, that is, my lord knows how possible it is. Those contributed to certain delays on part. In fact, they were also, the Border Roads Organization had acceded to it and had also extended the time limit. My lord, letter of extension is at page 54. Sorry, ma'am, this is the, my lord, I had requested for extension of time, and page 53, lordship will see the photographs. That is, I have been carrying out the work, page 53, and there are other photographs as well. I have been carrying out the work. Now, the issue here is, my lord, they have now terminated the contract. They had issued show cause earlier. I replied to it. But they have terminated by the impugned order. The impugned termination order is from page 64. This is 25th of October 2024, but we received it much later. Page 64, annexure 16. My lord, they have, it's a longish one, my lord. My lord may come directly to page 70. Or page 69, just before that. My lord, clause 16 of this termination order. In the light of aforesaid non-exhaustive fundamental breaches to the contract and in view of the contractor's persistent and sustained gross defaults, the authority is hereby notifying termination of contract on account of contractor's default under the provisions of clause 23.1 so and so. The provisions of article 23 shall henceforth apply. As a consequence, in accordance with clause 23.4, upon termination of this agreement, in accordance with terms of article 23, the contractor shall comply and conform to the following: deliver all relevant so and so, my lord. So by this, my lord, I have been terminated. Now they refer to clause 23. I have annexed that clause 23 from page 72. How the termination is to be done. 23.1 is, my lord, may directly come to page 74. It's a continuation of clause 23.1, Roman 2. Without prejudice to any other rights or remedies which the authority may have under this agreement, upon occurrence of a contractor's default, the authority shall be entitled to terminate this agreement by issuing a termination notice to the contractor, not a termination order, a termination notice, provided that before issuing the termination notice, the authority shall by notice inform the contractor of its intention to issue the termination notice and grant 15 days to the contractor to make representation, and after the expiry of such 15 days, whether or not it is in receipt of such representation, issue the termination notice. So, my lord, mandatory requirement is before they want to terminate, they'll have to mandatorily issue a notice saying that they are going to terminate and give us 15 days time to make a representation. There is no such notice issued to me. Then clause 3, my lord. The following shall apply in respect of cure of any of the defaults and or breaches of this agreement. The cure period shall commence from the date of notice by the authority to the contractor, asking the latter to cure the breach, and so on and so forth. My lord, this is not there. This is not complied with. So this impugned termination order, my lord, is in violation of clause 23.1, Roman 2. So therefore, they could not have issued. My lord, in a similar case, my lord, concerning bridges, my lord, a coordinate bench was pleased to pass an order. Now, my lord will see what is the effect of this. This is in the China border, I understand, my lord. So roads are important. But at the same time, my lord, during floods, how can the work be done? It cannot be. Now is the season. My machinery, including my piling machine, which costs a lot, it's very expensive, my lord. And the transportation also is very expensive. I had transported all the way to the border area. It is lying there. I am in a position to carry out the work. But let us look at what is the consequence of this termination. Consequence is they will have to float a tender. They'll have to re-tender the work. My lord, the work cannot start by the end of next year. Even if they float the tender now, even if the tender process has to take some time, it will take some time. So this season, starting from October onwards, now it's November. November to March is the time when the bridge is to be constructed, can be constructed. My lord, they are simply wasting their time. So what I implore lordships is, lordship will issue notice in this matter, and lordship will kindly stay the termination order, because it is in the national interest, my lord. Because it's a China border, my machinery, plants, everything is there. And if they want an undertaking, I can complete the work. I can complete the work. So, but on the other hand, my lord, if they re-tender it, it will simply push the work farther. So it is in national interest, my lord, if the termination order is stayed and I am allowed to do the work.
My lord, in fact, we have already filed on the caveat, the caveat petition, my lord. That caveat petition may be, my lord, disposed. Wherein, my lord, we have enclosed a copy of the, my lord, the termination order dated 25th October 2024, my lord. Caveat 87. My lord, basic contention is, my lord, contractual agreement was entered into between the parties on 9 May 2022, my lord. Thereafter, my lord, there was no, my lord, the significant developments in the development work.
9 May 2022.
My lord, Annexure 34, page 34, Annexure 4, my lord. Formal agreement entered into between the parties, my lord. 9 May 2022, my lord. Read petition, my lord. Page number 34, my lord. And thereafter, my lord, there was no significant development. And several, my lord, the correspondence were made to the contractor
my lord, may kindly come to again page number 43,
40?
my lord. This is the milestones, my lord, to be achieved in pace-wise manner, my lord. First milestones, recommended, second milestone second, milestone third, and serial of completion, my lord. Serial of completion, original date as per the serial J, 24th June 2024, my lord, 730 days. And proposed, my lord, recommended, but till such time, no, there was no development or execution of the work. So exactly, my lord, the contractor, my lord, given undertaking before the authority concerned to execute the work timely, but again that has not been complied with, my lord. The undertaking given by the contractor is at page number, my lord, 656, man. Page 56, man, of writ petition. Undertaking given by the contractor through proprietor. I series so and so do hereby undertakes that the above mentions the work shall be completed by 31st August 2024, man. The time, progress, and cert is enclosed herewith. Sir, very also prepared.
Undertaking was given on which date?
Page number, my lord,
No, undertaking was given on date? 5th of
undertaking
February.
date
5th February
5th February 2024, my lord. And cert paper was also prepared. Thereafter, that has not been taken into the action as per the undertaking given by the contractor. Again, the correspondence were made. Now, may I take your lordships to the again termination of the matter. Everything has been specified by the authorities concerned before termination of everything. Page number 64, annexure 16. This is the final termination order. Malanipran has referred that no so cause notice was issued to the contractor.
I said show cause notice was issued. Notice of intention to terminate was not issued.
Everything, this is the first page, page 64, annexure 16. Please refer to the following correspondence, Serial number 1, A to H. Again, J to U. Several correspondence were made to the contractor, petitioner. And wherein so cause notice is also given at page number, serial number, serial number S. Authority / headquarter CE project, the Aruna letter number so and so, dated 18 April 2022, under which so cause notice was issued. Thereafter, several correspondence were made. And the milestones, next page, page number 66, same annexure, Milestone 1, partly achieved the current status. Milestone 2, not achieved. Milestone 3, not achieved. And serial completion, not achieved. Remark. This is the very reasons the authority taken a decisions to terminate the contractual agreement made with. So there is a the delay in execution of the work. So therefore, this the contractual agreement made between the parties were terminated by the authority concerned. So therefore, my lord, at this stage, I'm basically, my lord, since the termination has already been done, and even if my lord, the lordship interfere by the impugn order, my lord, that will again the revocation of the my lord, the contractual agreement made with. So therefore, at this stage, my lord, let the notice may be issued, my lord, will file the necessary.
My lord, here, what my learned friend referred to the show cause notice. My lord, show cause notice is not the same as termination notice. If my lord comes to page 74, before termination, they have to issue a notice in that they are intending to terminate and give 15 days time. That has not been done. So this termination notice is in violation of the contract itself. So now, my lord, if it is not stayed, what would be the effect? If someone else is awarded the work, they will, even if my writ petition is heard later on, if they're without a stay, my lord, a third party right would be created. And if he carries out the work, then the illegal termination cannot, even if it is set aside by this honorable court later, my lord, what would be the effect? The writ petition would be rendered infructuous. So therefore, my lord, here this termination order which is issued illegally in violation of clause 23.1 Roman 2, that needs to be stayed, my lord. Both, my lord, in violation of the contract itself. Secondly, my lord, because there was no notice of intended termination given as required by the contract. Thirdly, my lord, because I am in a position to carry out the work in public interest, my lord, if someone else is awarded the work pursuant to a fresh tender, if the delay will, my lord, persist. For another 1 year, they will not be able to start the work. And the delay, I accept the delay. The reason for the delay, my lord, was the objection of the local people. I cannot work in that place, my lord, when the local people are claiming the land to be theirs. My lord knows the situation. When they claim the land to be theirs, my lord, if I carry out the work, if I proceed with the work, I'm not given any security. They will kill all my, I should not make that submission. There will be some problems. So therefore, my lord, in this situation, my lord, it's imperative that a stay be granted, my lord. Otherwise, the writ petition would be rendered infructuous on 3 counts, my lord.
Therefore, we have filed, my lord, caveat petition, wherein, my lord, we have already initiated the process for the, my lord, the assessment of the entire thing, my lord. That they initiated for the retender, my lord. After cancellation, my lord, work has to be completed by the department by issuing press tender, my lord, to the other, my lord, the tender.
My lord,
therefore, that has already been initiated the moment they have already terminated. That's because this has been, my lord, obtained. My lord, the approval has been obtained from the ministry, my lord. So therefore, my lord, the department has already initiated for the, my lord, calling of the press tender.
My lord, the cat is now out of the bag. Why they want to terminate? Because there is someone else waiting. That is the reason the cat is now out of the bag. The apparent illegality is there, my lord.
No, my lord.
And that is why, my lord, caveat.
It will be often tender. It will be online tender.
Of course, we know, my lord. My lord, otherwise the government department filing a caveat, we have to serve a copy on the council, on the government council before filing. So what is the need for the caveat? That shows
And in
why
similar,
the cat.
in similar case, lordship has already seen in the similar case, my lord, in one of the Harsa construction case.
I have placed.
Yes, my lord. That's the documents which my friend placed is, my lord, in respect of, my lord, the no coercive action should be taken against the petitioner. That to that extent, my lord, we are.
My lord, and no retender, and I should be allowed to continue the work. That termination order be stayed.
Mr. P.D. Nair, the learned counsel for the petition. And also heard Mr. M. Pato, the learned DSGI for the respondent. Through the present writ petition, the termination order
20 people, an excess. 20 feet off to the.
Termination
Basic.
order number 80260/A&K/70 dated 25/10/2024. Who is under challenge. Termination order is at page
My lord, termination order starts from my lord 64.
60. By whereby the contract agreement with the present petition has been cancelled by the department concerned. Next one. It is submitted by Mr. P.D. Nair, the counsel for the petition, and probably for issue notice, returnable within 3 weeks. As you are representing 1, 2,
My lord, all the respondents.
all the
All respondents.
as Mr. Katu, the DSGI has represented all the respondents, no formal notice is required to be.
1, 2, 3.
However, the copy of the requisite copy of the petition be furnished to the respondents. It is submitted by Mr. Nair, the counsel for the petition, that after the the 5/9/2022, no?
My lord, yes, madam. It's 9/5/2020.
Sorry, 9/5.
Page 34. It's for 2 years.
After the work, or the work order was awarded in favor of the petition, there was an agreement. Agreement was entered on 5/9/5.
9/5.
9/5. It is page number.
Page number 34, madam.
Entered into an agreement on 9/5/2023.
22.
Sorry, 22. Time was 2 years.
2 years.
The stipulated time for completion of the work was 2 years. 2 years. However, and accordingly, the present petitioner started to work on the project. However, due to interruption made by the present local people of the locality, he could not start his work. And moreover, due to flood, the old bridge was there, no?
Old Bailey Bridge, madam.
Due to collapse of the old bridge, which was deposited in the construction site, the work could not be, work could not progress. However, he intimated to the department concerned regarding his as to why the work could not be is not in progress by his several correspondence to the department concerned. But without any notice and to the present petitioner, the concerned department has, the respondent authority has terminated the passed the termination order on 25/10/2024. 5/10/2024. From the termination notice was issued under clause 23.1 of the contract agreement. However, the clause 20, they did not comply with, the department did not comply with the clause 23.1 oblique Roman 2, small bracket or small Roman 2 of the clause, whereby the notice has to issued explaining the intention of uh, the authority for cancellation of or cancellation / termination of the work. Without complying those provision, the termination order has been passed, which is itself is illegal and arbitrary. Accordingly, it is submitted by Mr. Nair that till the returnable date, till the disposal of the present application, the order of termination may be stayed. Next, para Mr. Kato, the learned DSGI, representing the state respondent, submitted in this regard that this so-called every correspondence was made with the present petitioner before the order of termination order issued before issuance of the termination order, and from clause S of the said termination order, it is very much evident that on 18/4/2024, the show cause notice was also issued to the present petitioner, intimating so cause notice was issued to the present petitioner before issuing the termination order. He further submitted that the agreement was the parties were entered into agreement on 9/5/2022, but even after expiry of 2 years, and even after filing the undertaking, there was no progress in the work, and for which the authority had to cancel to terminate. They had to pass the order of termination. Next point. Hearing this submission made by the Honorable Counsel for both sides, considering all aspects of the case, this court is of opinion that till returnable date, no coercive action shall be taken in terms of the termination order dated 25/10/2024, issued by the Office of
The Chief Engineer. Chief Engineer, Madam, Project Arunank. Page 70, Madam. Page 64 also the address is there, Madam. Chief Engineer, Project Arunank, signed by the
Chief Engineer,
Project Arunank. Page 64.
Chief Engineer, Project Arunank, ARUNANK, Arunank. List the matter accordingly after 3 days.
Madam, the termination, if it's stayed, Madam, Madam. But if that is mentioned, my lord, that would be
No, it's already mentioned.
mentioned, Madam. Deeply obliged.
Take you, caveat to dispose to it. Caveat teachers will order, pass the order. No, no. This is good. This is.
Malad,
You have filed your.
the state, they are yet to file.
You have
We
filed.
had filed for respondent number 3, Manoj. For 1 and 2, we need some more time.
For respondent number 3, you have filed.
Yes.
For 1 and 2, you need some time.
Yes, Manoj.
Who is representing this 4? Estate officer. Four is represented by whom? 4?
Me only.
So you yet to file the affidavit in opposition for 1, 2, and 4. 4 you are not going to file.
No, no, 4, we won't be filing. Your Lordship.
You won't be filing for 1 and 2. Heard Mr. T. Tarum, the learned counsel for the petition. And also heard Ms. So-and-so for the learned government advocate. You're for education, you're for
Earlier, Mr. P. Tapo, he was there, but now he resigned, so we'll be appealing for UD.
So-and-so has represented the respondents, and it is submitted that affidavit in opposition has already been filed on behalf of respondent number 3, but she needs some more time to file the affidavit in opposition on behalf of respondent number 1 and 2. How many weeks you need?
2 weeks.
2 weeks. Let the matter be listed after 2 weeks, enabling the state respondent number 1 and 2 to file their affidavit in opposition.
And my lord, interim order passed earlier may continue.
Interim order passed earlier shall continue till next day.
Deeply obliged.
May my Lordship, in this, we need some more time. Lordship.
You are for the respondent?
Yes, ma'am.
No one has represented the petitioner. However, Ms. So-and-so, the learned government advocate, sought some more time to file their affidavit in opposition on behalf of the respondents. Prayer allowed? 2 weeks or 3 weeks?
3 weeks.
3 weeks. This is the matter according to 3 weeks, enabling the respondent to file their affidavit in opposition.
Number 16.
Yes.
My lord, am I allowed to take a press tape, respondent number 2, 3, 4, and 5, 6?
One has already.
One,
Basically, we are not necessary party. The other respondents are the main respondent.
Acha. IOCL, this is
BPCL, Bharat Petroleum.
So basically respondents are Union of India, Bharat Petroleum, no?
Madam.
Bharat Petroleum.
Director, 2, 3, 4, 5.
And 6.
6. Not yet.
6 is a private respondent.
Private respondent. Heard.
Arnabam. Arnabam.
Heard Mr. Arnabam, learned counsel for the petition, and also heard Mr. M. Khatter, learned DSGI, representing respondent number 1. However, it is paid by the respondent petition to take fresh steps on the respondent number 2 to 6. Prayer allowed. The petitioner will take steps accordingly and issuing notice to the respondent number 2 to 6. List after 4 weeks. After
My lord, this interim to continue.
interim was there, no? Yes. Interim will continue till instead of listing. It will be listed after 4 weeks.
Master Complaints.
Number 17.
May I plead for your lordship? My lord, in this matter, we have taken step through Dusty, and they have received on 27/5/2024.
Affidavit you have filed?
The deputy commissioner has filed a counter affidavit, but then other party, the NHPC, they have received the this one notice on 27 as per the record.
Presence the NSPC.
I'm appearing for respondent
NSPC?
No, my lord. I'm appearing for deputy commissioner, respondent number 9, my lord.
So, my lord, may I pray that
Who is the councillor, NSPC standing council?
Kamal Saxena.
Kamal Saxena, but his name is not reflected in the cost list, my lord. So may I pray that his name may be reflected in the cost list.
But he is the only one who is representing the NHPC or
No,
other?
PK Tiwari also, madam.
He is the only one. But without his consent, can it be?
PK Tiwari.
No, no. সেইটো কোৱা নাই তেওঁৰ কনসেন্ট নোলাকে তেওঁৰ নামটো ৰিফ্লেক্ট কৰিব দিব পাৰিম জানো তেওঁ নাই নেকি
Otherwise, almost all the NSPC matters they are
Yes,
representing.
fine.
They are representing.
but still without in his absence you have filed your affidavit in this regard regarding the Dusty Moore service.
We have filed the
Affidavit.
affidavit of service on 29/5. We have filed on 29/5/2024. And the dusty service was done on 27/5. 27/5.
27/5/2024.
Yes. And then we filed the affidavit of services on 29/5.
Information নাই নেকি কোনটো necessary party হয় office note to put
They are necessary pattern, my lord. Don't.
some 5/4 I need to appear Brian. Their number 4.
Yes.
Phone number
4, 7, and 8.
4, 7, and 8. Okay. Dusty Moore and DS. But you have filed your affidavit and you have stated that the Dusty mode is already the notice has already been served to Dusty.
Yes.
And you have submitted the date of Dusty was 27/5/2024.
Yes.
And
yes.
another date you have given, you have filed your affidavit on 29/5. But why the order was passed on 13/6/2024? Oh, acha, so you have already filed your affidavit.
We have already filed.
Sure. Then what to do?
Well, sectioner's name may be reflected, and next time, if they don't want to represent, then they can. Otherwise, it will be keep pending, my lord, that way, my lord. Next time also, it will happen the same way, my lord.
Do you have any? আমার পুরো মোড আছে নাকি আমি ইনফর্ম করব একে সেকশন ইনফর্ম করব Okay, through registry will try to inform without prior to reflecting his name will try to inform to our registry
Yes, that can.
as he is dealing with the cases of an HPC. So we'll adhere to it in that
Then,
context. They are the respondent number 4 or
4, 7, and 8.
4, 7, and 8. So 1, 1, 2.
Well, I put the 1 and 2.
1 and 2. You have already filed your
No,
affidavit.
my lord, our affidavit may not be required because the NSPC basically is taking up the project work.
Yes, obviously. 1 and 2. And you are representing?
9, madam.
9, private respondent.
No, my lord.
Deputy
Deputy Commission, sorry.
They have filed affidavit.
You are? 3. You want to file your affidavit or no? Necessary. Okay. The person heard Mr. S. Pound, the learned counsel for the petition. Also heard Mr. M. Khattu, the learned DSG, represent the respondent number 1 and 2. And MS Swenson, the government advocate for representing the respondent number 9 and Mr. Swenson representing the respondent number 3. However, it is submitted by Mr. Mark that the notice has already been served to Dusty Moore on respondent number 4,
7, and 8.
and 8. And this affidavit has also been filed in that regard by the petition on 29/5/2024. 24 postal. And in that context, Mr. Patil has submitted that generally the cases of NHPC is represented by the learned counsel, Mr. A.K. Saxena, and his name may be reflected accordingly in the cause list. in that regard, I find it, this court is of opinion that the Mr. A.K. Saxena, the counsel who is representing the NHPC may be informed so that he may represent the respond number 4, 7, and 8 on the next date of listing. The registry will do the needful according. So we are directing the registry to inform him.
Bless you.
If the matter, when can it be listed then?
Maybe after 1 week.
After?
1 week, my lord.
After 1 week.
Date can be given, my lord.
After 1 week will be, I think, serve your purpose after 1 week. Date can be given.
Then.
Because it has to be informed to Saxena
Yes,
that
yes,
he will appear.
Yes.
Let it be after 2 weeks.
2 weeks, no issue.
After 2.
2 week date may be given.
You want any fixed date? Fixed date.
Fixed.
You want any fixed date?
Yes.
Okay, fixed date. 2
Fixed
weeks
date may be
also.
given, my lord, 2 weeks. Huh?
26, 11.
You've done.
Apply.
Lordship, I'm appearing for
Tip
respondent number 1 and 4.
18. Petitioner side is not here. Ako conduction item number 18. Item number 18 will approve a conduction.
Number 18, 21.
Oh, you are here.
Your
Yes.
Honor, on behalf of petitioner counsel,
Who is he?
Rajesh Majumdar.
Huh?
3 weeks that may be given.
No. You are representing whom? Your engaged counsel. Who is your engaged counsel?
Majumdar, Rajesh
Majumdar?
Majumdar, yes.
Majumdar.
Majumdar.
Majumdar নাম তো নাই যে এটা। Majumdar's name is not here.
18.
See, you are representing item number 18 or 19?
18, no.
You hold back.
59, sir.
PD Nair is here only.
He was here, but
PD Nair ulai gol dekhun ei matro. But PD Nair is here. Kune কাকে represent করেছে এখানে কাকে জানি না ঠিক। That ulai gol. Achha, anyway, what is the issue now?
Your Lordship, I have filed my affidavit, Your Lordship. I'm for respondent number 1 to 4.
You have for respond number 1 to 4.
For 2 and 3. Some more time may be given to file our affidavit.
So 1 and 2 has already filed.
4, Lordship.
1 and 4.
Yes. On behalf of 4, we have filed our affidavit. On behalf of 4.
Only for 4?
Yes, Your Lordship.
1 is represented by...
1 is Chief Secretary, Your Lordship. So from state respondent, we have filed our affidavit, Your Lordship.
No, that's what I'm asking you. You have filed your affidavit on behalf of 1 and 4.
Yes, Your Lordship.
And 2 and 3 you are representing?
Yes.
You need some time. 1 and 2 can already affidavit in opposition you will file. 2 and 3 sought some more time to file its affidavit in opposition. All right, your good name is?
Nbui.
Nbui. And I will heard Mr. Nbui, the counsel for the petitioner. Your name is also not here now. Nbui, appearing on behalf of Mr. P.D. Nair for the petition. So how many weeks you need?
3 weeks.
3 weeks. List after 3 weeks. Enabling the respond number 2 and 3 to file their affidavit in opposition. Okay.
No, Lordship.
Number 19.
Lordship, respondent number 1 and 2, they have filed their affidavit. There's one private respondent, he has not filed their affidavit. Now it is in the order column. And now if they want to file, it's okay. Otherwise, the matter may be put for admission column, Lordship.
Yes.
My lord,
Yes, you are representing whom?
I'm representing my lord state respondent, my lord.
State respondent number?
State respondent number, my lord. 1 and 2, my lord.
1 and 2.
Yes, my lord.
So 1 and 2, you have not filed. your
I have already filed.
For
the
1
private-
and 2 file.
Yes. And the private respondents there, they have not yet filed. And my lord, one thing, during the pendency of this case, my lord, the selection process, the entire has been declared null and void, my lord. And recommendation made thereof has been cancelled, my lord. And they have, the petition has brought it on record, the subsequent order passed by the authority. That's the selection process.
Process is already been.
Yes, it's been cancelled, my lord. In that case, my respectful submission, my humble understanding, that this matter become infraxis. Because
He is challenging,
he's challenging the appointment, the recommendation made in favor of the petitioner.
Acha.
Now, subsequently, during the pendency, that entire selection process has been declared null and void, and it has been cancelled and directed for re-advertisement. So, in that view of the matter, there's a subsequent development, my lord.
is there
The
anything
matter.
to say in that regard?
Lordship, it's, let it be put in the admission column. I'll render reply of the subsequent development. In fact, they should come with the affidavit filing the cancellation order. So
So
there
in
is
your
a,
affidavit, it has not been incorporated in your.
That's
No,
not
no.
correct. That
After-
if so record, we can bring it on record also. But since they have already filed the affidavit, madam, additional affidavit, by way of additional affidavit, they have brought in the cancellation order. That's why,
My lord, they have filed one additional affidavit, my lord.
So you have already
Petitioners.
filed.
yes,
we have filed. We
It
have
is there.
filed intimating
It is
the
on
honorable.
record.
they've already brought on record.
We have,
Additional affidavit filed by the written petitioner.
we have filed to bring it on record. Although this should have been done by the government, department side.
Then you.
Now,
The last
now-
time we shot for, sorry to disturb, we shot for mentioning this, but there was an opinion from this court that we should bring it on record. We are in the process actually, within a short time they have filed, that's why, madam. Otherwise we could have filed.
in fact, this is the real contempt. There is a stay order from this honorable court. After having a stay order, after finding no way to escape and to oust me, they have done that. So that is the real contempt, which we will reply once they file the affidavit.
My lord, when the root is gone, my lord, what is the meaning of the leaves and trees, my lord?
Anyway,
The entire
so
process has been declared null and void, my lord.
I can
So,
understand.
my lord, no.
Now, as per you, who is yet to file your affidavit in opposition?
Lordship, private respondent is.
You are for the private
Yes,
respondent.
Yes,
three.
in the affidavit of the government, they have said the private respondent has joined. Now they are saying that private respondent did not join. So if he has joined, there has to be a termination order. Now I am in the waiting list in their appointment order. So where do I go? My waiting list I should be getting. That's the point.
Now see, this is now the position has been changed, that entire process of the selection process has been cancelled, I think.
Lordship.
So now the position,
The-
he will also revert back to the.
There has to,
Also.
Lordship, there has to be a reason. We are medical officers. We have the requisite qualifications. On basis of my qualification, the selection process was done. And I have been kept in the wait list number 1. Only 2 were selected. So the other one who was selected, she did not have PhD degree. So we challenged that before this honorable court. After finding that, now they have taken into that exercise, which nullified it, and misleading the honorable court, and that took pure contempt after passing of interim order. How can they play that way? That will,
My lord,
So that's why, Lordship, for today, my prayer would be, if they want to file a affidavit, there's their liberty. Now, otherwise, let the matter be put into admission column so that it may be heard. Since it is in the order column, so I'm limited to that.
You bring it on record.
This is all already on record, my lord. They've already filed the additional affidavit bringing that the cancellation order. If still they insist that required, there's no issue.
We'd like to hear from the government.
In that case, we can file no issue. This cancellation order that is not been done out of nowhere because of this cancellation was done at the behest of the petitioner. Petitioner lodged the complaint, and basing on complaint was considered. After examining all facts, the cancellation was this. His representation has been disposed of, culminating the cancellation order, and that entire selection process in which he also participated, that has been declared null and void. Now there's a fresh advertisement is ordered for, so matter become infraxis.
And my lord, by filing,
It was a common advertisement for other department also. So that has this department has been chosen and this has been cancelled. So anyway, Lordship, for admission.
Okay. No, to be an you take one, use another one. Mr. A. Appan, the learned senior counsel assisted by Anju, Mr. N. Anju, for the petition, and also heard Mr. T. Lagum, the learned counsel. Effective senior government for the response number 1 and 2, and also heard Mr. B. Picha, the counsel for the private response number 3. The response number 1 and 2 has already filed their affidavit in opposition. However, the response number 3 is yet to file his affidavit in opposition. Mr. Tagum submitted in this regard that by the subsequent development, the entire selection process has been cancelled, and hence the present the petition has already become infructuous. Mr. Picha also submitted in this regard by the additional affidavit, the petitioner has brought into record regarding the cancellation order, and hence the entire petition has become infructuous. Next pattern. Mr. Appan submitted that the government is to produce, and government may be directed to produce the official records regarding the cancellation of the selection process, and the matter may be listed for in admission column, and so that it can be heard and finally disposed of. Considering this submission made by the Learned Counsel for both sides, the state respondent is hereby asked to produce the official records. In
that case, we may be allowed to leave may be granted to file the additional affidavit, the additional instead of producing record, additional affidavit will file,
Maybe allowed to file may file their additional affidavit to bring the record regarding the cancellation process, regarding the cancellation of the selection process. Full stop. And let the matter be accordingly listed in admission column. When you can be able to,
Earlier the better, Lordship.
Okay. Can it be on 20 November? 20?
20.
Lordship,
in admission.
Lordship, earlier interim order may continue and then list it for admission hearing, Lordship.
It's no reason at all, but I don't know.
If
it is continued also.
Yes, because it's already gone.
No, Lordship, as a matter of practice and procedure,
Circumstances, he is erecting me.
Lordship, as a,
You can say
Lordship, as a matter of practice and procedure, they will have to file an application for vacation of the interim order. So since that is not there, so it has to be continued, Lordship.
By the other way, no purpose will serve.
More fruitful purpose.
Serve anyway, if you insist, then we'll continue the interim order.
Declare.
Number 21.
Yes.
My lord, this matter is about non-publication of advertisement in the newspaper, my lord.
No, it is in order, column. Why it is in order?
Yes, my lord, on last occasion, my lord.
Service is still awaited. Service is still awaited for respondent number 427. Is it awaited?
Okay, my lord.
Respondent number 427 services. Service for the respondent number 427 is still awaited or what? Now, as per office note, I am saying
My lord, I think service has been completed, my lord.
completed.
My lord, right. My lord, in that case,
I don't know. Where is the note, office note? Where from it can be held that the service is completed? Because I have find one note on 29/10/2024 as well as on 4/11/2024. The service is still awaited in respect of 427.
my lord, in that case, I will take first step
You want to
against the
take first
private.
step?
Yes, my lord. And my lord,
Want any dusty also?
that's the my lord also.
Vote in both way you take. Yes, another what you want to submit?
My lord, one thing is, my lord, on last occasion, my lord, Lord additional senior government advocate. So submitted that, my lord, I am the petitioner, appear in the, my lord, said examination, my lord. Appear in the said examination. My contention is that I did not participate in the examination, my lord. Since because paper publication was not done, I was unaware of the advertisement, my lord. That was my condition. But the state government council submitted that I appeared in the exam. My name is reflected in the serial number 11, my lord, 11. In the, they have furnished one, my lord, document where the list of eligible candidate was given, my lord. And in the serial number 11, that same, my lord, my contention that that particular person and I am both are same name, my lord, Taimara. Both of us is known as Taimara. But my contention is that I'm not the one who is appearing in the
This will
examination.
be decided now. After it is cases in order stage, let them file. You have filed your affidavit of opposition. Not yet. Then where from he is saying that you brought those things that he also participated in this? Is there any other document you have filed?
No, my lordship, we'll be filing, my lordship. So.
So they will be filing. Also
Yes, yes,
from where
let
you are
them
saying-
file to reply, my lord.
No, from where you are saying?
My lord?
That they have.
No, no,
We had the.
No, you
instruction.
have, but they have not filed.
not
yet.
file anything, man, not file anything.
So from where you are saying?
Last time they had submitted one document. Yes, before this one.
Document
Yes,
submitted.
yes, yes, madam.
Okay.
So let them file affidavit then, madam. And meanwhile, I'll take a fresh step against the private respondent.
Then you want to say that you have not participated?
I did not participate, my lord. I did not participate, my lord. Because my details are given in my writ petition, my lord. Entire my annex details, my father name, my village name, my educational qualification is given in my writ petition, my lord.
So state is representing
So if they-
1, 2. You are 1, 2.
1, 2, 3.
1, 2, 3. One, two, three. 4, 1, 2, 3 represent করে আছে স্টে গভর্নমেন্ট অ্যাডভোকেট পেটিশনাৰৰ কাৰণে হাৰ্ড আছে দি নাম আছে লিখিব আৰু আৰু হেল্প কুৰ্ডু চাগে এডভোকেট আৰু
El Kurdu.
Yes, 4, 5 the office note dated 4/11/2024 reveals that the service is still awaited for respondent number 4, 5, 6, 7 and 7. And accordingly, the petitioner is hereby asked to take fresh steps on the respondent number 4, 5, 6 and 7 to register post as well as anti-dusty service is also allowed. directing to file affidavit in that in regards to service of notice to district. Further, MS Swenson paid some more time to file their affidavit in opposition. Prayer allowed. Let the matter be listed accordingly. You need how many weeks? 2 weeks? 3 weeks. After 3 weeks. List after 3. You take steps.
Yes, my lord, on last occasion, if notice was not issued, notice,
Notice was issued. Notice was not issued. Yes. No, notice was to issued. See the order of 22/10/2024. See the order. It was.
my lord, notice was not issued, my lord, instruction was sought from the state government, my lord.
No, order of issuance of notice was there, in fact. 22/10/2024.
22
To whom you're saying, no, for the respondent?
for the respondent, my lord.
The order of notice, issuance of notice was there in the order dated 22/10/2024. See the order, issue of notice. Issue notice to the respondent.
My lord, that will
So I am asking you to take fresh steps on the respondent.
Yes,
number
my
4 to
lord,
7
that I will do,
to register post as well as in testimony.
my lord,
So they are going to file the affidavit in opposition. Most probably they will bring the record all these
my lord.
things and then.
And my lord, one line may observe that outcome, any appointment if carried out shall be subject to the outcome of this writ petition, my lord. Because appointment already carried out, my lord.
No, you should submit all these things before on the first date of listing. It will not passing any of that.
Obliged,
3
my lord.
weeks already.
Number 9.
Wait, Your Lordship.
Yes.
I'm sorry, my lord, I was engaged in video conferencing in 2 courts, my lord.
From which court?
In one in the Justice Yates court, in one in Justice Borua's court.
Oh.
There was some review matter, my lord.
Achha.
This is a my lord, simple case, my lord. The deputy commissioner, while exercising his power under the Arunachal Pradesh Eviction of Unauthorized Occupants Act, as an appellate authority, my lord, has exercised the power as if he is a court and has passed an order condoning a delay of 1880 days in an application filed under Section 5 of the Limitation Act. It is clearly impermissible, your lordship is aware of it. There are catenas of decisions by the Supreme Court that statutory authorities are not courts. They cannot pass any order if the limitation is provided in the statute beyond that. Section 5 does not apply to statutory bodies. I just give the facts, my lord. Your lordship may kindly have page 27. Page 24 first, my lord. Before that, my lord, if your lordship may kindly have for a moment have the Arunachal Pradesh Code, volume 8.
Volume.
Page number 160.
160,
man. This is the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act 2003 for a eviction of persons illegal occupation of public premises. The deputy commissioner, your lordship will see in the definition at 2. Deputy commissioner means the deputy commissioner in charge of a district. Now, notices are issued at page 162. Notices are issued by the estate officers under Section 4, and orders of evictions are passed under Section 5, 6, and 7. Now, my lord will kindly have Section 12, 169. An appeal shall lie from every order of the estate officer made in respect of any public premises under Section 5 or Section 7 or Section 8 or Section 10 to an appellate officer who shall be the deputy commissioner of the district in which the public premises are situated. An appeal under subsection 1 shall be preferred. A. In case of an appeal from an order under Section 5, we are concerned with this, within 30 days from the date of publication of the order. So that is the limitation prescribed. "30 days. Now, your lordship may have page 24 of the petition. Page 24. This is the complaint, my lord, on account of the private respondent encroaching upon the school land, my lord, of a village called Main, my lord, in Sangdupota Circle, my lord. This is submitted by the petitioner in his capacity as chairman of the school management committee. I will not bother your lordship with the contents matter. The law issue is very limited matter. As page 27, is the notice under section 4, man, issued by the estate officer. At page 28 is the order of eviction, my lord, under section 5. Page 28 it starts. Your lordship will find at page 30. The respond page 30, my lord. Therefore, it is hereby strictly ordered that the respondents is such and such shall halt and remove all constructions, erections in the land under question, including such and such, within a period of 15 days, as per section 5 of the Arunachal Pradesh Public Premises Act, madam. Section 5, 30 days limitation. What he does after that, instead of filing an appeal under section 12, he approaches the civil judge senior division. That is at page 31. Then, my lord, page 47 is the order of the civil judge senior division. Page 47, my lord. He dismisses saying that you should have approached under section 12 and there is a bar, civil courts bar. So thereafter also, instead of filing an appeal under section 12, he files a title appeal, my lord, before the district judge. That is at page 56. That was also dismissed. This was, my lord, to kindly note the date. This was dismissed by a judgment dated 4/11/2022. 4/11/2022. Thereafter, my lord, at page 65, he files the appeal before the deputy commissioner. For 4/11/2022, an appeal is filed at page 67. My lord will kindly see. I'm showing this because it's not even protected under section 14 of the Limitation Act. He files it after 15 months. Date of filing is 13/2/2024 at page 67.
Captain?
13/02/2024.
After 7 months.
After 15 months. This is 2024. Judgment was 4/11/2022. Along with this, my lord will kindly see there is an page 96 interlocutory application under section 5 of the Limitation Act. For condoning a delay of 1880 days. This was allowed by the impugn order at page 122. This was allowed. As I was submitting earlier, my lord, it's not a court. Limitation Act, section 5 is applicable only to courts, my lord. It was absolutely without jurisdiction. Did I need to rely on any judgments, my lord? It's a settled position of law. There are lots of judgments, my lord. I am just relying upon one. 1996, 9 SCC 414. Small paragraphs. This is under the Electricity Act. For the land, paragraph 18, madam. Land Acquisition Act. Paragraph 18. Though hard it may be, in view of the specific limitation provided under the proviso to section 18(2) of the Act, that is the Land Acquisition Act, we have the considered view that subsection 2 of section 29 cannot be applied to the proviso to subsection 2 of section 18. The collector, Land Acquisition Act, therefore, is not a court when he acts as a statutory authority under section 18(1). Therefore, section 5 of the Limitation Act cannot be applied for extension of the period of limitation prescribed under the proviso such and such. Admittedly, but it's a statutory authority under the Land Eviction Act, my lord. It's not a court. Limitation Act applies only to courts, my lord. I pray, my lord, for notice, my lord, and stay of the impugned order, as well as the proceedings, my lord, the appeal proceedings. At page 122, my lord, will find the IA number as well as the appeal number, my lord. These two needs to be stayed.
Yes. Notice may be issued, Your Lordship.
But to consider the interim prayer, my lord, otherwise an illegal proceeding will go on.
Since Your Lordship, private respondent is going to be directly affected by the stay order, Your Lordship. So on the next day, Lordship, interim prayer may be considered, Your Lordship.
Hardly find why my colleagues from the government side make such kind of submissions. Why is he holding the brief for the private respondent? Make the submissions what I say on law is wrong. Can the issue is, my lord, can the deputy commissioner, is the deputy commissioner under the Eviction Act is a court? No, the answer is no. The Supreme Court is very clear. So how can, my lord, be allowed to proceed, my lord? Meaning there, if your lordship does not stay, the proceedings, which could not just, cannot go on, will be allowed to proceed, my lord.
Yes, Your Lordship, but after condoning the this one interim interlocutory application, Your Lordship, the DC has directed the respondent to file the written statement, Your Lordship. But that day on 4/10/2024, Your Lordship, but that day no order was passed, Your Lordship, and he was the next date was fixed on 4/11/24, yesterday, Your Lordship. So what has happened yesterday, Your Lordship?
That has been adjourned, man. That has been adjourned and has been fixed on 22. That, even that is not the issue, my lord. Ultimately, the issue is matter whether deputy could had the jurisdiction to pass that order, my lord.
Mr. D. Payne, the learned counsel for the petition, and also heard MS E. Wango, the learned government advocate, for the respondent number. You are for the respondent number then? One, no, not one.
One and two, Your Lordship.
1 and 2.
3 is the private respondent.
Only 1 and 2. Swenson. Baki likhibo, listen application, Swenson. Against a then the interlocutory implementing order dated 30/08/2024 passed by the Deputy Commissioner in interlocutory application PP/JUD 0954/2024 in civil appeal number DC/PP-01/0954/2024 by condoning the delay of 1880 days in preferring the connected appeal under section 12 of the Ownership Studies Public Service Public Premises packet of eviction of unauthorized occupants packet close Act of 2023 before the Deputy Commissioner for Papumpari District against the order dated 19/7/2019 and 02/08/2019 passed by the estate officer Sangdukota, Papumpari District. Issue notice on the respondents returnable within 3 weeks. No formal notice is required to be sworn so voidable. Next point, it is submitted by Mr. Pangni, the learned counsel for the petition, that the The private respondent number 3 filed the petition.
Yes.
Private respondent number 3.
Yes.
The private respondent number 3, after the order of eviction passed by the estate officer, initially filed an appeal before the civil judge senior division, which was dismissed on the count of jurisdiction, and thereafter he again approached the district judge with an title appeal, and the same was also dismissed by the district judge. Thereafter, after a delay of after 15 months of the order passed by the learned civil judge senior division on
District judge, ma'am.
district judge on 4/11/2022, he filed a petition before the appeal before the deputy commissioner under section 12 of the said act, wherein with a delay of 183 days.
880, ma'am.
No, 188.
1880 days.
1880.
Yes.
180 days. 0 days, which was accordingly condoned by the deputy commissioner while dealing with the said appeal. He further submitted that the state authority acting state authority who dealt with the appeal under section 12 of the said act cannot discharge his duty as a court and cannot we cannot allow a petition condoning the delay, and as per section 12 also, the appeal has to be filed before the deputy commissioner as an appellate authority within 30 days from the date of eviction order passed by the estate officer. Thus, the order passed by the learned deputy commissioner, privacy illegal and arbitrary and without jurisdiction.
Yes.
Accordingly, he submitted a brief that the further proceeding in before the learned deputy commissioner in connection with that appeal number.
Civil appeal number, page 122.
No, appeal number you have given here also.
Yes, civil appeal number DC/PP-01/0954/2024.
May be state in disposal of the present. Next paragraph. MS so-and-so, the learned government advocate submitted in this regard that if the stay order of appeal may directly affect the private respondent number 3, as the appeal has already been admitted condoning the delay by the deputy commissioner so-and-so. Next paragraph. Considering this submission made by the counsel for both sides and in the aspects of the case, this court is of opinion that this court finds it necessary to stay the further proceeding in the appeal number so-and-so
Civil appeal.
before the learned, which is pending before the learned deputy commissioner so-and-so till the returnable date. List accordingly after 4 weeks. You take steps on the private respondent number 3. Okay, it will be stated.
Okay.
Challenging this impugn order at page 108. Well, in English, normally we call it as a white collar crime. But I don't know how the translation word in Assamese would be.
Bogarongor crime.
Bogarongor crime. Here, that Bogarongor crime is an elephant who doesn't know what is technical and what is non-technical. Of course, non-technical he can fit into, my lord. My lord, kindly come to page 108, my lord. I'll not take so much of the time. But...
Yes, 108.
Yes, well, 108, annexure 4, what had happened is, this is that Vibrant Village project thing that is going on in Arunachal. So what had happened? The technical bid was, according to them, technical bid was, impugned technical minutes report was issued on 15/10/2024. That is a date. Now,
For technical bid.
yes, in terms of clause 22.6, this upload has to be done within a period of 5 working days. Now, 15/10, my lord will record. And then my lord will kindly come to page 108 on the top, my lord, right side. According, what is this tender summary report, my lord? The date is on 3rd November 2024. Because, my lord, once the technical bid is open in terms of this guidelines, the financial bid has to be open in another 3 days. Right? So, my lord will kindly come to the second box, bid list, my lord, bid list. Bid list status updated, my lord. My lord will kindly see 28/6/24 p.m. 28/10 6 p.m. my lord, 6:24 p.m.
Yes.
Now my lord will see from my lord, if counts 15/10, it is uploaded after 13 days. Now my lord, to this context, my lord, I'll show the guidelines. My lord will kindly come to page 49. 49. Yeah. It starts from page 48, my lord. Kindly come. How first thing they have violated, my lord. Judgment very rare. My lord, how bid has to open, my lord? Page 48 first. 22. Sorry, my lord. There is a caveat may be discharged.
Yes.
I'm so sorry, my lord. Normally we cannot proceed with her. Yes. My lord. So now my lord has seen 15/10/2024, the technical bid evaluation was done, and my bid was rejected on a non-existing ground, my lord. And it was uploaded on 28/10/2024 at 6:24 p.m. Now, what the guideline says, because my lord, Katina of judgment says, tendering authority are the best author of the tender documents because they have authored it. Accordingly, they have framed the guidelines. Now, kindly see, Miller, bid opening and evaluation process. Miller, we will skip a lot of things. Miller, kindly come, 22. My younger says 22.3 should be read. They are very useful sometimes. In all cases, 22.3, in all cases, the amount of bid security, cost of bid documents, and the validity of the bid shall be scrutinized. Thereafter, the bidder's names and such other detail as the employer may consider appropriate will be notified as Part 1 bidding opening summary by the authority inviting bids at the online opening. A separate electronic summary of the opening is generated and kept online. Now, okay, 22.5. Now, my lord, kindly come to 22.5. Evaluation of Part 1 of bids with respect to bid scrutiny, security, qualification information, and other information furnished in Part 1 of the bid in pursuant of clause 12.1 of ITB shall be taken up and completed within 5 working days, my lord. Kindly see. They have violated their own set of norms. Of the date of bid opening, and a list will be drawn up of the qualified bidders whose part 2 of bids are eligible for opening. Now, my lord, dramatically, they have done the technical evaluation bid on 15/10/2024, uploaded on 28 after 13 days. Now, this was communicated, my lord, on 3rd. This was page 108, my lord, will come back. It was communicated on 3rd November at 8:48. Now see the intention, my lord. This is very unfortunate, my lord. Now, my lord, once my brother Nair was very playfully, described how the gate was behind his back in another matter a while ago. My lord, the moment after 2 decades of standing on the legs, what I understand is the moment there is a caveat, the first presumption, my lord, most of the lordships does is, yes, there are some arbitrary and malified exercise of power. Exactly is my case, my lord. This is, my lord, how I have fulfilled all the criteria and qualifications, my lord, in terms of the ITV. Where is that page? Page 49, my lord. No. My lord will kindly come. I'll demonstrate, kindly come to Annexure 3, page 28 to 107, my lord. My lord will kindly come to page 42 straight.
40?
41. 41. It is BD standard operating this thing, my lord. It is. Now, the ground of rejection is page 40, my lord. It starts because the impugn order says my tender document has been rejected in terms of 4.b, my lord. B and bracket
4.4b.
4.4b, my lord. This. Now, page 40. Then now page 41, my lord. Kindly see B. Roman 1, Roman 2. Now, if this is the first criteria of rejection of my bid, my lord, kindly come to page 122 straight, my lord. I'll demonstrate. Availability of construction work, my lord, B sub Roman 1. The criteria is each bidder must demonstrate availability for construction work either owned or on lease or on hire of the key equipment stated in the appendix to ITB. My lord, this first criteria I have fulfilled. This is my documents. I have annexed it, my lord. Page 122, please.
122
Yes.
is technical portion.
Yes. And then there is one more, my lord. I'll also, my lord. 156, my lord. This is for the technical person and 156 is there, my lord. Yeah. See, eh? He is a machinery. My lord, that first criteria, machinery, 156, my lord. This I have the post submitted before you. Then, my lord, 2. My lord, that availability for construction work of technical person as stated, that is what I have shown in page 122, my lord. The grounds which you have invoked to reject my technical bid falls flat, my lord, in terms of this documents which I have annexed. This is a part of my bidding documents, my lord. Now, my lord, another important aspect in this case is page 42, my lord. My lord will see 4.7, page 42. 4.72, the another ground which they have rejected me. 72, no? 4.72. For that purpose, my lord will kindly come to, this has to be read with my lord page 186. Huh?
No, 4.7.
2, I'll read, my lord, for a moment. 47 are close to Record of poor performance such as abandoning the works, not properly completing the contract, inordinate delays in completion, litigation history or financial failures, etc. and all. For that purpose, my lord, my bid document, my lord will find at page 186. My lord, this is this is 47.4.7.2. I have fulfilled. This is my documents, my lord. Kindly see. No litigation or arbitrations. This is, my lord. Now, my lord, kindly come to page 190. I'll demonstrate everything. Solvency certificate, my lord. That's 190. 25. My lord, this apart, I have fulfilled. I have been rejected. Serial number 5 of the technical beat, technical beat. Now, there should be a fairness in tender evaluation process, my lord. And the apex court in Bandi Prasad's Bandisa Private Limited construction, I told him to take a printout. He has not brought it. I'll provide the judgment. We say there must be a fairness and there should be a non-arbitrary and mala-fide exercise of power by the tendering authority while deciding this. Now, here in this case, my lord, not only level playing field was granted to me, but it is actuated with the mala-fide and arbitrariness. My lord, these has come in the form of conversation between executive engineer, my lord, Chain Tajo RWD division. That, my lord, and he is also, my lord, district project implementation unit, my lord. Now, what happens? The executive engineer, my lord, is the key person for implementation of this project. Now, he has been kept out of the tender evaluation process, and the tender technical evaluation bid was evaluated by the personal assistant of the superintending engineer come chairman, my lord. That I'll demonstrate, my lord. I have given I have annexed a certificate under section 63 of Bharatiya Saksha Adhiniyam Sanhita, that is Indian Evidence Act, my lord. That requirement under is section 65B of the old Repeal Act now, because this is electronic evidence now. No, where is that? But this conversation, my lord, because I have made a statement, this is a 9 minutes and 22-second conversation between executive engineer and one of the representative of another firm. It discloses but how they have done it. I'm placing it for the record. So, because this requirement, my lord, I'll come to the transcript version. It's a very, my lord, every tender, my lord, is filled with murky and murkiness, my lord. I don't know how the state functions in this manner, my lord. My lord, kindly come to page 95, my lord. 195. That is the certificate, my lord. Just I'm pointing.
195.
195, my lord. Because this is a requirement under law, my lord. Otherwise, I cannot place it. This mobile number, my lord, I'm trying to.
Okay, this will definitely it will.
Yes, my lord. That. Now, my lord, kindly come. The conversation, the transcript part, page 196 onward. Well, it is a conversation. 9 minutes is 22 seconds, but I have seen 22 seconds. I think it is here. Taku Pagya, Executive Engineer RWD Chain Tajo, and Sri Sonam, representative of MS Monil, whose firm has also been rejected. It stands at serial number 3. Well, first 1 minute, someone on the other issues, Miller. So, hello, this My company MS Monial Enterprise had not received any information about tender related feedback and why I should tell lie to you. Thus executive engineer says, no, you better check mail. I had talked to concerned official. Once it is uploaded in the website, the result automatically appears in both winner and loser company, participants, email and message. Nothing as such has come till third. Till third, Malok, this is correct, Malok. Till third, we have received nothing. Then that Sonam says, yes, I had just now confirmed about the receipt of a message from tender official. That is, my lord, this conversation was held on first. Cousin brother, are you not confused about the actual tender package which I referred? My package number is construction of Seva Venya Road to Yakli via Dia, package number so and so opening. You all might have opened the package so and so. And then the engineer says, oh, no, it is not possible. And once SC office upload it, then it will come automatically to the participant. My lord will mark this. This is important conversation. For information may be winner or loser as per system. Mr. Sonam, that's true, cousin brother, but we should have been invited in the time of opening technical bids. Now it is on the electronic record, my lord, that evidence in the definition clause, now electronic record has been made as an evidence, my lord. So, but technical bid did not invite us. My lord, clearly, prima facie it says that we were not invited. It is mistake of department side. No. Checking no one is invited. It is done secretly. Opening time bidders have been invited. Letting all participants in the firm is so and so. Now, next, this page is very important, my lord. That Kaku Pagya, executive, you are not authorized. There may be network problem for uploading. I had asked. It should be available once it is uploaded in the website for both winner or the loser. Mr. Sonam, how is it possible? Our attendance without invitation formation for officials. There is no information system. It is done only online system. Mr. So-and-so. For example, as your extension matter, where you rejected us based on our document, scanned copy and need original copy of document in the matter of 120 days bid validity. Oh, bid validity. You gave us 3 days time, opportunity to produce original copy who have not brought original copy of 120 days bid, which I produced it within 24 hours. In executive engineer Kaku. Oh, on that point, your technical bid offer might have not rejected. Reasons of rejection might have come to your email. Somehow, reason of rejection will come to your given email. Mr. Sonam, if you have the online portal, says it. How could it can't come to me? It is not possible my own. DAC or BAC lying in SC of my lord will mark this. Because the DAC means
Now this conversation is between whom?
The executive engineer who is supposed to conduct the evaluation board as a member secretary. And the superintending engineer, my lord, is the chairman of the technical evaluation board. Now, my lord, kindly come to one particular last page, 198. Who was doing, my lord, this PA, my lord? Mr. Singh Chung, PA person might be doing it all. You mean technical bid part has been open and decided, right? Yes, I am told that technical bid has been open for scrutiny. So now I am confused. Now, my lord, that's why I said this white elephant. Everything, my lord. I don't know what is happening in this state, my lord. Every project which is brought here is put into challenge before this honorable court.
Yeah, that is there.
The very unfortunate, my lord. I am saying, at least you give them a equal level playing field. You want to award the work to somebody, you do it. That is not our concern. But probity and fairness demand, there should be a transparent manner. Judgment. Well, that Bandi Prasad judgment, I'll just furnish that. But right from Tata Cellular paragraph 94 is that 94. I'll provide this. The authorities are with me. It clearly says that unless the entire process is vitiated by the arbitrary and mala fide exercise of the power by the authorities, judicial review should not be done. Here, my lord, I have demonstrated my case. And then is a latest judgment after NG product, which my brother Tarak used to rely NG product on 2022. He says no interim order, nothing as such. Now the Supreme Court has overcome this proposition, saying that, well, just give me 1 minute, Milord. Seems my youngers, Milord, they must have overworked whole night. Just print, I think from my mobile. Anyway, Milord, that particular judgment is here. I can provide the judgment. Yes, it is there. Yes, Milord, that it says civil appeal number, Milord, 11005 of 2024. Milord, I will provide this. Just and 2024 BANS Bansidhar, BANSHIDHAR Construction Private Limited versus Bharat Coking Coal Limited and others. Respondent. Here, the apex court in paragraph reiterating all the principles, apex court has said it has said that there should be a fairness without arbitrary exercise of the power, Milord. And then paragraph 26, Milord, the judicial review of Jagdish Mandal judgment is the most popular judgment, Milord, in tender matter, Milord. Paragraph 22 is always quoted here, Milord. That I'll provide it, Milord, with this along with after some time, kindly provide it. So, Milord, kindly prima facie. That's why it got late. We have informed at 10:30. Milord, in our system, the moment the litigation is filed in the High Court, what happens? The officer normally, in respect of the judicial institution, ought to have deferred for some time, but there they have gone ahead with opening. This is most unfortunate part that the executive, Milord, they always undermine the judiciary. Moment the matter becomes sub judice, once there is a sub judice, suppose once there is a sub judice, in that case, it might be this way or that way, Milord. In that even what happened? If it goes against you, there will be a contempt consequences, that which they don't know, Milord. So therefore, Milord, prima facie is the case. Milord, they have not finalized the tender. I have made a categorical statement. I have demonstrated my case, Milord. Let
Not
him
yet
file.
finalized.
Yes, Milord. They have opened the financial bid today. That's why I'm saying, Milord. 10:30, I made a mention. I informed my brother. And then at 12 o'clock, they have opened the financial bid. This is not supposed to do, Milord. Then, Milord, what had happened? After financial bid is open, Milord, then then agreement will be drawn, Milord. Then first agreement, then letter of intent will be issued, Milord. Then the agreement will be drawn, then work to proceed will be there. So that means, Milord, the tender process has not been finalized. So therefore, Milord, prima facie stay this, and with an option, Milord. My Lord will stay this with a rider. The impugn NIT shall not be finalized. Pending disposal of this writ petition. However, if it is not finalized, that part, my Lord, then what happens? Let my brother come back with thing. He'll file the affidavit, because prima facie on material, my Lord, it is suffice to say.
May I please, my lord, before coming to this petition, my learned friend have put serious allegations that executive engineer was kept out of the tender process, and technical bid was done by the PA of the. So that matter may be recorded. That may be recorded.
Yes, I have.
If it is not true, then on that ground only this petition be dismissed.
I have record.
So on 7th, I'll produce the record. So I'll record may be called. Till then, on 7th we'll produce the record. So it is not possible to executive engineer and how the committee will open the technical bids. Then it will evaluate. After evaluation, then it will be prepared and it will be published. After publication, if it is uploaded online portal, then within 5 working days, any bidders who is agreed by the decision of technical evaluation committee may submit representation to the committee. Then within 5 working days, they has to pass a resolution. But in this case, representation was purportedly submitted by them on 4th yesterday only.
Because
And
on third, my lord,
it has been never received to any of the authority till today. So financial bid was open today.
my lord, that
So
that submission, my lord,
till now, my only humble submission that we will call, I will produce the record. Then the matter will be taken up 7th. If any interim order is to fast, it may be passed on 7th. Otherwise, on record,
no, my lord,
petition itself, there is petitioner has failed to establish any premier facie case. The machinery on which ground his bid was rejected. Although he had submitted some lease deed, but there is no any other document to support his that he have possessed or he have taken lease of that
no.
registration number, insurance number. That has to be produced. Nothing is in the writ petition.
No, my lord, my friend
So
argument,
let matter be list 7th.
till then, if tender should not be finalized, my lord.
Till then, nothing will happen.
No, but it has to be. Prima facie, I have demonstrated. Because in terms of 22.6, my lord, once the technical bid is open on 15/10/2024, then you are supposed to do it on 18, my lord.
My lord,
And then it has been listed, it has done after 15 days. So,
the annexure for 100, page 18, the summary which he have annexed, that is also incomplete documents. This is also incomplete documents. Detailed summary has to be there.
It's, I have annexed the detailed summary in my cabinet petition as an annex. It's consists of 3 pages. It's clearly written there.
my lord, he has not provided me the copy of the
I
KV.
have already sent to the poster. That's the procedure of it.
He has to,
They have
he has,
proceeded as-
my lord, whether receiving or not, it is immaterial. But as a matter of ethics and equity, you are bound to provide me. My lord, this submission is also illegal because what they are saying is it is incomplete. How does it is incomplete? It is a electronic generated record, my lord. It is not made by me.
No, they are saying it's incomplete.
Yes.
No, that's why I don't know why. What is this incomplete that I don't?
Pages are missing, I think.
My lord,
This is not the complete one, I think, as per their submission. I don't know.
that
Evaluation summary, it has to be
let them-
there.
my lord, let them.
Now we'll
come-
produce on Monday,
let them
7th.
come with the affidavit detail. But my lord,
7th.
my lord, only thing is that this particular superintending engineer, who is the chairman of technical evaluation board, is always in the eye of storm. Every decision of this particular superintending engineer is put into challenge in this court, my lord. I think some cloud is there. That's why, my lord, this is a white elephant, my lord. Something need to be done and the department is sleeping
My
and
lord.
trying to defend. my lord.
But out of this is out of context.
No, it's
Even
not-
petitioner knows. All that tender put to tender.
this is
It put to
something.
challenge because there is two political rival groups.
No, that
They
is-
knows.
that is your concern. But what, as a
And they used to
as a-
withdraw also.
as a responsible citizen, as a court officer, just I have made this submission because before I went abroad, 2 months back, I have done so many cases against this man, till seven,
Day after tomorrow only.
till
Nothing
seven, no, you cannot proceed.
I'll probably tell them not to proceed, but no order.
Well,
is
well,
for-
kindly bring it up. Kindly till seven, restrain them from giving final.
Otherwise, this is
finalization.
developmental. If this order is passed, again, they will started delaying
No.
the.
I am ready for final argument on seven. Let him file, make an observation that he will file affidavit by tomorrow.
No, no,
And-
for this record, by 7,
No.
it will not possible to
See,
file affidavit.
Milord, I have this better experience. These officers, they will send all the manufactured documents. Manufacturing of forged documents in Arunachal government officials.
It's
are
very,
not-
very unfortunate and unsubstantiated.
No, I was part of this. I was additional AG, I know how things have worked. Therefore, Milord, let him file affidavit.
Order, harshly and so prohibitable. And the challenge kit order is to the video. And thereafter you write you are the caveat, no?
Yes, I'm okay.
Caveat has to be discharged. No, you have not received the copy.
I have not received.
How Mr. So-and-so appearing on behalf of the private respondent, you make it. And then it is submitted next para. It is submitted by Ms. Chitara. Then that on next date of listing, that is on they will produce the official government official records before the court and record person. In that context, Mr. Tara, the land counsel for the petitioner, submitted that till the next date of listing, there may be a stay order not to finalize the tender process.
With that, Milord, endeavor shall be made for final disposal on 7th, with the condition that they will file the affidavit tomorrow and give a copy to me. Milord, I will respectfully submit, Milord.
Tomorrow, for affidavit may not be possible.
Because,
for them.
no, Milord,
But
under
however,
oath.
he is saying that he will going to produce all the documents on 7. If in that day,
Milord,
suppose any interim order is passed. Today, I'm also passing an interim order.
Yes.
Staying not to finalize the
Correct.
as
That's
interim, not to finalize on 7th.
Till 7th. Grateful.
So you file the official records on 7th.
Yeah.
And if the affidavit in opposition can be filed, then it's very nice, very good only. But otherwise we'll hear to it and we'll see the official records.
Grateful. Grateful.
Now, as per you, the allegation or whatever is brought by the Mr. Tara regarding the absence of executive officer while opening the technical bid.
That is
That is,
postponed around this petition should be dismissed. He cannot.
No, I'll tell my client.
put such a-
Because I'm on instruction work, because my client has provided and given certificate under section 63. And then, Milord, no, Milord, he has confirmed that executive engineer is not in the loop of opening the tender process. What fraud is to be established? Fraud reaches everything, my brother. I'll come with the
But
authority.
it's a very strange thing that Mr. Tala has submitted that in every, projects, wherever any tender process is there, it definitely put to challenge before this court. Why this is happening, in fact?
I know.
But I have submitted maybe due to political some
In
reasons.
reality, there is something different in context of Arunachal Pradesh. Even the petitioner who come before this court, they are not the owner of the farm.
Mm,
Even the farm, sometimes farm owner, they don't know whether the petition is filed or not.
mm.
This is the situation prevailing here.
But, my lord,
After
in,
passing, they will blackmail the officers, they'll get something and withdraw, and another part.
So these things, I think the developmental, the projects are being very suffering in. this
no, well,
particular-
I'm also concerned. My lord, I'm also really concerned for we as a council. number of cases, number of earnings are there. But sometimes we also feel obligated to tell the client. I asked my client repeatedly, is this conversation true or not? So then he said, कि sir confirmed है इसीलिए मैं दे रहा हूँ.
to get a pin code. See? Pin power reduce. Page of power রাখি থৈ দিব. এটা মোৰ সুবিধা বাকিটা নহয় আপুনি. I have recorded your submission almost here, so
Right.
no need to submit further.
No,
I
I'm
have
not
already recorded.
I am not submitting anything. Only stays there, that's great.
While sitting, my legs are not paining in fact.
Okay.
While standing, যেটি একটা pressure পড়ে in that my ankle region, then it start paining actually.
We pray for
I had
early
some
recovery.
this nerve what দুখ পাই গলো নেকি, I don't know. Yesterday while I was going from court, then only it
I'll
happened.
try to find out some local experts.
No, really. Okay.